think this matter may be listed, Your Worship.
Give me the last one.
Last order for next case. And for the response.
Just sit down. Just have a seat. When do you want?
Lordship, it's Friday if it may be listed because there are just 2 days when my Lord's bench is available for that matter, Your Lordship.
Thursday would be better.
Oblige, Your Lordship.
Thursday.
Because the petitioners are knowing a stay, my Lords, in that matter.
Okay.
Oblige, much obliged.
Have you informed the petitioner?
I'll inform him, my Lords, because it was already there on
Take the
16th.
slip, inform them, get the signature, and put the date as Thursday. It will be
I'll
done.
list. I'll do that. Oblige.
From supplementary list. Item 1 WPS 212 of 2023.
We'll ignore the defect for the present. You argue your case. Argue.
Prayer with regard that the petitioner who was appointed on the post of CRPF constable
When?
in the
Date
year
of appointment.
1971.
Then?
Then he discharged duty and in the year of 1983 on 4/5/1983 to 26/5/1984. Total days of 380 days he was absent.
4/5/1983 to
26/5/1984. 26/5/1984.
absent. Then?
The case of the petitioner
Then what happened? Give us the dates.
thereafter, my lord, notices were sent by the respondent authority, but he has not turned up. But subsequently he has made application and given resignation to the authority.
When? And where is your resignation letter? Date of resignation and what is the day? Where is your resignation letter? Are you not ready? You go through the records, right? We'll pass it over.
थोड़ा सा अगर 10-15 मिनट टाइम
10-15 मिनट में 12 बजे take.
हाँ
Passover matters are taken up at 12.
हाँ मान
You just prepare a list of dates. You are challenging the order of dismissal of 1984,
Yes.
right?
Yes.
Yes. In the year 2023.
Since
You need to explain.
Since this order of
We will see that. You need to explain. You have been convicted also.
Yes, ma'am.
Yes.
For press filing item 2, WPS 1294 of 2023.
Yes, ma'am.
Your Ladyship, as per yesterday, para 17 of the writ inquiry, Your Ladyship, in that the violated rules of 169 and for 310 of the prison manual, for the sensitive matter that he has, for him only the prisoner has escaped from the
No, we
jail.
appreciate everything. That was not the query of the court.
For that only the documents have not been
The
given.
query
The
of the
enclosures.
no.
The enclosures of
No.
according
He
to
has
para
repeatedly made protest that the enclosures were not handed over.
Yes, Your Ladyship, for that only.
And your subsequent orders also does not deal with it, right? So even if you say that it was handed over, that really does not serve the purpose, isn't
Your
it?
Ladyship, in para 16 that we have given him chance.
You
that
forget
chance,
about para 16.
Page 16.
You
of
just let
counter-
us know one thing, madam.
Yes.
If the inquiry report consists of enclosures,
We have given him chance, Your Ladyship.
chance means chance for what?
For sure, we have provided him show cause to reply, Your Ladyship.
To reply to the inquiry report.
Yes, Your
Right?
Ladyship.
Where is that? Where is his reply?
एक
Let us
मौका
see.
पुनः दिया जाता है.
Let us see. Second show cause, no? Page number
Page
43.
16.
Page 43, please. Page 43.
Page 43.
Read the bottom line. Page 43.
भव्य कार्यालय के ज्ञापक 2627 जेल दिनांक 16/10/2015 के द्वारा मुझे 15 दिनों के अंदर द्वितीय कारण परीक्षा आरोप के संबंध दी गई निर्देशित पत्र में विभागीय कार्यवाही संचालन पदाधिकारी के द्वारा समर्पित जांच प्रतिवेदन की मूल प्रति की छाया प्रति उपलब्ध कराई गई, परंतु जांच प्रतिवेदन में संलग्न अभिलेखों की छाया प्रति स्पष्टीकरण हेतु उपलब्ध नहीं कराई जा सकी। फलतः मैंने दिनांक 3/11/2015 को आवेदन के माध्यम से संबंधित जांच अभिलेखों की मांग की ताकि स्पष्ट कारण परीक्षा पर स्पष्टीकरण समर्पित कर सकूं। भवदीय स्तर से निर्धारित समय खत्म होने की स्थिति में को मद्देनजर रखते हुए जांच में संलग्न अभिलेखों के अभाव में अभिलेख प्राप्ति के बाद भी पुनः अभिलेख के बाद पूरक स्पष्टीकरण के आधार सुरक्षित रखते हुए मैं द्वितीय कारण परीक्षा पर सादा स्पष्ट कर रहा हूँ।
That's right. So he stated in the second show cause that the enclosures have not been provided to him. Now let us see how do you deal with this in your final order.
It should be.
Now you explain whether this aspect has been dealt with. Have you stated in your final order that you were provided with the show cause, this inquiry report with its enclosure?
Enclosure nowhere it has been provided.
So therefore, that from the stage of second show cause, the matter has to be remitted back to the authority. This he has raised even before the appellate authority, who did not consider it, who also did not say anything on this. So these aspects are required to be looked into.
Ladyship, the disciplinary authority as well as the appellate authority passed the impugned
They have
order.
not considered this. He has got a right to have a look at the enclosures to the inquiry report. Had there been no enclosure, there was no grievance. But the inquiry report had its number of enclosures. So there has been a gross violation of natural justice. Explain.
Your Ladyship, after considering the facts and the documents, only the impugned order has been, and which were available on record, the impugned order has been passed, Your Ladyship.
According to you as a counsel, natural justice has been violated or not? I'm testing your knowledge as a counsel. Don't behave like a litigant. It will come to you only. You consider everything. Pass a very good order. He has also said that he was not given opportunity to cross-examine the witnesses. So all these things you verify from the inquiry report and the inquiry proceedings and find out, and you can record a finding that he was given an opportunity, he did not avail of it.
जांच तो हुई थी, Your Ladyship. That also we have annexed in page 17. दिनांक 2000 की मंडल
On this short point only I will dispose of the matter, nothing more. Mr. Sani, kindly
Yes.
give me the foundational dates.
Yes,
Date of charge sheet,
yes. Date of
charge memo.
Date of 29th June 2006, Annexure 1, page 27. 29th June 2006.
What was the major charge? That you had
I
helped
was the
somebody to
gate
escape.
warden. Gate
You had
warden.
helped somebody to escape.
Yes.
All right.
Then what this
Inquiry report.
so-called the explanation was submitted on 25th of August 2006.
25,
8 2006. Annexure
You
2.
denied.
Yes, I denied not and explained
That's right,
Then
forget it.
on
Inquiry
18th
report.
March, 18, sorry, inquiry report is 29/9/2015, annexure 5, page 36. Second show cause notice was issued.
Just a moment. You participated?
Yes, participated, but no opportunity of cross-examination, and the copy of the preliminary inquiry report. Those are the objections
We
raised.
do not know. We will not enter into that. But you participated.
Participated, yes. Then on 16th October 2015 is the second show cause notice.
Second show cause.
Then 3/11/2015, annexure 7 is the reply to the second show cause notice. Which was being read.
That's
Then 21/11/2015. Sorry. Then the 30th July, 30th March 2016 is the order, impugn order of dismissal from charge. Then I prepared appeal. That is memo of appeal note is annexure 10 on 9/5/2016. Page 51.
You again raised the grievance regarding
Yes.
non-submission.
Yes, appeal or memo of appeal also
That's
contains this fact.
That's
Then when the appeal was not being disposed of, I approached this honorable court, it was disposed of the writ petition WPS 6850 of 2017.
6850 of 2017. Disposed of on
9th July 2019.
9/7/2019.
19.
Okay.
Then the impugn order.
Then you file your representation once again.
Representation
What is the date?
communicating the order of this
What is the date?
27th August 2019.
Okay.
Then the appellate order note, annexure 30, page 61, 23rd October 2019.
लिखिए. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that there has been gross violation of principles of natural justice in the present case. He has also submitted and has submitted that the inquiry proceedings was not conducted in compliance with the principles of natural justice, and further, so far as second show cause notice is concerned, only the copy of the inquiry report was handed over to the petitioner, but the enclosures to the inquiry report was never handed over. The learned counsel has submitted that while responding to the second show cause, the petitioner had objected to the fact that the enclosure to the inquiry report was not handed over and had demanded the same, but had no option but to file response to the second show cause without having the enclosure to the inquiry report. He submits that he reserved his right to file additional reply to the second show cause. The learned counsel further submits that the order of dismissal was passed on 30/3/2016 without providing him the enclosure to the inquiry report, and the objection raised by the petitioner in his second show cause reply with regard to non-furnishing of enclosure to the to the inquiry report has not been considered. The learned counsel further submits that appeal was filed on 9/5/2016, and when the appeal was not being
One thing not in memo, but it was specifically taken.
appeal was filed on 9/5/2016. In the state memo of appeal also,
Page 50.
Specific plea was raised in connection with non-furnishing of enclosure to the inquiry report. But the appellate authority also did not consider this aspect of the matter and other points raised by the petitioner and dismissed the appeal by impugned order dated 23/10/2019. The Learned Counsel has also submitted that while the appeal was pending and was not being disposed of, the petitioner had filed a writ petition being WPS number 6850 of 2017, which was disposed of by the order dated 9/7/2019, enabling directing the appellate authority to dispose of the appeal expeditiously. The Learned Counsel has also referred to paragraph 17 of the writ petition, wherein and submits that it has been specifically mentioned in paragraph 17 that the documents referred to in the inquiry report were not provided to the petitioner. He submits that such statement has not been denied by the respondents in their counter affidavit. The Learned Counsel has submitted that enclosures to the inquiry report, enclosure to the inquiry report which formed a part of the inquiry report itself, having not been handed over to the petitioner, the petitioner was deprived of giving proper response to the second show cause, and accordingly the impugned orders call for interference by the state. The Learned Counsel appearing on behalf of the respondents while opposing the prayer of the petitioner has submitted that the proceeding that there are serious allegations against the petitioner. The proceedings were conducted in accordance with the principles of natural justice, and the petitioner was given second show cause, to which he responded, and every aspect of the matter has been considered, and therefore the impugned orders do not call for interference under limited jurisdiction under Article 226 of the Constitution of India. However, during the course of argument, the counsel for the petitioner is not in a position to point out any discussion in the impugned orders regarding non-furnishing of enclosures to the inquiry report to the petitioner, though the inquiry report was admittedly served upon the petitioner. That's it.
Counsel for the respondent.
Respondents. After hearing the Learned Counsel for the parties and going through the materials on record, this court finds that the petitioner was subjected to disciplinary proceedings and the allegations against the petitioner were served upon him by memo dated 29/6/2006, to which the petitioner denied the allegation by letter dated 25/8/2006. However, the petitioner was subjected to departmental proceedings in which the petitioner duly participated. The inquiry report is dated 29/9/2015 as contained in Annexure 5 to the writ petition. The inquiry report at the end refers to the inquiry report by itself is referring to various annexures, and at the end it shows that there was enclosure to the extent of 82 pages. The petitioner was issued second show cause dated 16/10/2015. The petitioner responded by taking a specific plea that the enclosures to the inquiry report was not provided to the petitioner and demanded the same, however reserved his right to file detailed reply once the enclosures are received. The disciplinary authority dismissed the petitioner by impugned order dated 30/3/2016. This court has gone through the order of dismissal and finds that the same has no discussion in connection with furnishing with the objection of the petitioner that enclosure to the inquiry report was never furnished to the petitioner. The petitioner filed appeal on 9/5/2016 and the memo of appeal is on record. In the memo of appeal also, the petitioner has raised a plea regarding non-furnishing of enclosure to the inquiry report. However, when the appeal remained pending, the petitioner filed a writ petition being WPS number 6850 of 2017, which was disposed of by the order dated 9/7/2019 with a direction upon the respondents to take a decision on the pending appeal within stipulated time frame. Consequently, the petitioner produced a copy of the order before the appellate authority on 27/8/2019 and the final order was passed on 23/10/2019. In the final order also, there is no discussion regarding furnishing of enclosures to the inquiry report to the petitioner. In the present writ petition, the similar grievance regarding the documents referred to in the inquiry report were not provided to the petitioner has been raised in paragraph 17, and such statement has not been denied by the respondents in their counter-affidavit. Thus, from the perusal of the records of this case and the pleadings on record, there is no doubt that the petitioner has been asking for the enclosures to the inquiry report right from his reply to the second show cause, but the same was never taken care of by the respondents while passing the order of dismissal dated 30/3/2016 as well as the appellate order dated 23/10/2019. This court is of the considered view that the inquiry report, that non-furnishing of enclosures to the inquiry report to the petitioner, which formed a part of the inquiry report, in spite of his specific request to furnish the same, cannot be justified in law, and the respondents have no explanation for not furnishing the same to the petitioner. In fact, this aspect of the matter has not been addressed in the counter-affidavit at all, nor the same has been addressed in the order of dismissal as well as the order passed by the appellate authority. In such circumstances, the impugned orders cannot be sustained in the eyes of law, which are accordingly set aside, and the matter is remitted to the disciplinary authority to pass fresh order to the disciplinary authority from the stage of the second show cause to pass fresh order in accordance with law after providing a copy of the enclosures to the inquiry report to the petitioner. This court has not, the needful be done within a period of 3 months from the date of production of a copy of this order. This court has not gone into the other merits, other points which has been raised by the petitioner in this writ petition, and it is open to the disciplinary authority to take a decision in accordance with law. The order of dismissal has been set aside only for the purposes of passing fresh order on the second show cause. And for no other purpose. This writ petition is accordingly disposed of.
Item 3, WPS 5549 of 2023.
Copy of the NCW.
Which clause is that?
Well, 9.3.3 deals with who would be the dependent. The dependent for this purpose means the wife, husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent, this is not of any avail. Unmarried daughter is the case.
So you are unmarried daughter?
Yes, I am unmarried daughter.
Yes.
And 9.5.0 deals with that if female dependent.
5.0. Yes. In case of death.
Death and my lord's medical unfit. Well, if I read my lords, the provision of the employment / monetary compensation to the female dependent of workmen who die while in service and who are declared medically unfit as per clause 9.4.0 above would be regulated as under. The second is relevant, my lords. In case of death, total permanent disablement due to cause other than
You file a
accident.
counter affidavit that has been denied by the impugned order.
No, nothing such. my lords. In fact, one of the
You have
judgments.
just filed your representation.
Yes, my certainly. My lords, otherwise, one of the judgments says, my lords, it would be duty bound upon the respondents.
We'll remit the matter to them to take a
Certainly.
decision. You have recently filed your
Khali-
representation
एक खाली-
on 9/8/23
Yes, ma'am.
only, and you filed the writ petition on
Yes, ma'am. My lords,
21/9.
Yes, ma'am, certainly. my lords.
So within a month you have filed it.
Yes, certainly. ma'am.
What is the date of death?
My lords, unfitness. my lords.
Date of unfitness.
Medically unfitness.
Give that foundational fact, please.
Yes.
Your mother or your father?
Father, my father.
5/1/2013.
Yes.
Okay. Now he has expired.
He has expired, my lords. He has
He has
expired.
expired on
My lords.
9/1/15. No.
No.
2110.
21. 21/10, 2014.
21 not 31. Just he pays 16.
Yes. 31. 31. I stand.
Thank you.
खाली एक बार हुजूर खाली एक चीज हम खाली बोलना चाह रहे थे इसमें.
What else? Let them take a decision.
Yes, my lords.
What do you have to say?
मतलब date of मतलब even if I will be मतलब entitled for it, तो वो from the date of
We
application.
will not decide whatever. They are aware of the law. You produce whatever judgments you want to produce before them, along with your writ records.
खाली in the light of खाली ये
We
खाली
will not say anything.
otherwise क्या
No,
करेंगे ना date of
they will
application.
pass. No, they will pass appropriate order. There is no reason that if you produce a judgment, they will not consider it. We will not decide the date.
मतलब
on which-
otherwise खाली उसको लिखवा
आप-
दीजिएगा ना कि if
आप
they
ऑर्डर
produce-
लिखाएंगे
नहीं
हाँ तो बस
Certain.
let them take a decision. We don't expect those authorities not to go by the law laid down by this court.
करते रहते तो यही है।
ऐसा नहीं करेंगे ना आप लोग. Please don't do that.
नहीं तो otherwise फिर के protracted litigation हो जाता है।
WPS number 5549 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the father of the petitioner, namely Banarsi Singh, was declared unfit by the respondent authorities on 5/1/2013 and subsequently he expired on 21/10/2014.
31.
31/10/2014. Thereafter, the mother of the petitioner endorsed the name of the brother, name of her brother for appointment on compassionate ground, which was rejected by respondents, against which a writ petition. Who was the writ petitioner in that case? The
My
brother.
brother, Deep Narayan.
Against which the brother filed a writ petition before this court in WPS number 1875 of 2016, which was allowed by the order dated 21/4/2017. The respondents prefer appeal being LPA number 521 of 2017 and the appeal was allowed in their favor. He submits that consequently, no compassionate appointment was ultimately given to the brother of the petitioner. The learned counsel submits that in case where a person, an employee is declared unfit or is declared medically unfit or expires while in service, the female dependent is entitled for monetary compensation. He submits that the monetary compensation ought to have been paid by the respondents themselves, but the same has not been paid. Mother has expired.
No, mother has not.
He submits that the mother of the petitioner is alive.
She's also a petitioner in this litigation.
Who is the co-petitioner in the present case? And she is petitioner number
3.
3. The council submits that a representation was filed by the petitioner number 1 before the general manager with the respondent number. Please tell us. Respondent number?
Respondent number 3.
Yes, before the respondent number 3, White letter sent through post
Yes.
on 9/8/2023 as contained in Annexure 5 of the writ petition, but no decision having been taken, the petitioner has filed the present writ petition seeking a mandamus upon the respondents. The learned counsel appearing on behalf of the respondents while opposing the prayer has submitted that the petitioner has rushed to this court by filing the writ petition on 21/9/2023, though the representation was sent through post only on 9/8/2023. However, he submits that there is no reason for not passing an appropriate order on the representation filed by the petitioner. He also submits that the writ petition be disposed of so that the petitioner may once again approach the respondent number 3 for passing appropriate order. After hearing the learned counsel for the parties and No counter affidavit has been filed in the present case, and no such order for filing of the counter affidavit has also been filed by this court so far. The facts narrated by the petitioner is based on materials available on their own. Considering the nature of relief sought for by the petitioner, this court finds that the parties were on litigating terms due to the claim of compassionate appointment by the petitioner number 2, which has been subsequently set at rest as stated by the petitioner. And ultimately, the petitioner number 1 has filed a representation before the respondent number 3 for seeking monetary benefit, which the petitioner claims to be payable in terms of national coal wage payment. In view of the aforesaid facts and circumstances, this writ petition is disposed of, enabling the petitioner to file a fresh representation before the respondent number 3, along with a copy of the writ records within a period of 15 days, 15 days from today. Upon filing of such representation, the respondent number 3 is directed to look into the grievance of the petitioners and pass appropriate reasoned order in accordance with law within a period of 1 month from the date of receipt of a copy of the representation. The respondent number 3 shall also take into consideration the various orders which have been annexed along with which has been annexed along with the writ petition, or any other order which may be produced by the parties. If the petitioners are found entitled for monetary compensation, by virtue of the reasoned order, the respondent number 3 is directed to take all steps so that the amount of monetary compensation is duly remitted to the account, joint account,
Only account.
to the account of the petitioners. You have to provide the account number, right? Female dependent, the petitioner number 2 may not be entitled.
Yes.
After is directed to remit the amount to the petitioners who are entitled for payment within a period of 1 month from the date of the reasoned order. The reasoned order be communicated to the petitioners through post, through speed post.
Item 4, WPS 5683 of 2023.
My lady, I have come before this honorable court in the previous
The
time.
learned counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. By how much time do you need?
My lord, 4 weeks will be granted since I have to seek instruction from finance and agriculture.
By 4th of March 2024, pose this case on 6th of March under the heading of admission.
Item 5, WPS 5715 of 2023.
Same order? Same order and same date. Abhi date. What is the date we have given?
6 March.
6th March. Counter by 4th of March.
Item 6, WPS 5727 of 2023.
Also, in this matter, the opposite party is Jharkhand Mineral Area Development Authority. The grievance, my lords, is that in the provident fund amount that is paid by respondent MADA, they are required to pay the interest as per
Do
the
you have
CPF
a
rules.
remedy under the law for seeking this relief?
But we
Do
are,
you have a remedy under the law?
but we are only concerned with non-implementation of the rules, my lords.
That's which
That's,
rules?
but CPF rules that they admit is applicable to Jharkhand Mineral Area Development Authority. They are paid up. They
Who
are
is
paying
the
up.
authority who will look into your grievance? Who is the authority who will look into your grievance?
But that is the managing director, madam.
Managing director.
Yes, ma'am.
He is
But
the authority under that?
Yes, ma'am. Presently, he is the authority who is, because the Jharkhand Mineral Area Development Authority is not existing. The authority that is required to be constituted under Act has not been constituted since 2005. In the absence of the body, only managing director is there, madam. He is having all the powers now.
Same order. Will call for a counter.
Obliged.
एक second order. The counsel for the respondents shall also the counter affidavit should also mention as to whether the petitioner has any remedy under the any statutory remedy available for redressal of his grievances.
Item 7, WPS 5734 of 2023.
It is a similar cases are pending arising out of the same imprint order, Lord.
Give me the case numbers.
I am supplying the These are batch of the cases, leadership in which what had happened that the petitioner and other similarly situated persons have been removed from service.
Okay. WPS number 5734 of 2023. The learned counsel for the petitioner has produced a copy of order dated 29/1/2024 and has submitted that the issue involved in the present case arise out of the same imprint orders as is involved in the cases referred to in order dated 21/1/2024. This court is of the considered view that the present case should be heard along with analogous cases. But the other cases are of the year 2021, which does not fall within the roster of this court. Accordingly, the office is directed to place this case before the Honorable Chief Justice along with order dated 21/1/2024 passed in WPS number 2127 of 2021 and other
It's
analysis.
29.
Sorry?
29.
Sorry, 29/1/2024. However, the respondents are directed to seek instructions.
They have already filed their counter affidavit. I will be praying for.
Counter affidavit in the present case has already been filed. The petitioner may file its a rejoinder to the same within a period of 1 week from today. 7/3 को है ना, उसके पहले फाइल कर दीजिए. वो सेंटेंस अधूरा रहेगा. The office is directed to place this case before the Honorable Chief Justice along with order dated 29/1/2024 passed in WPS number 2127 of 2021 and other analogous cases, so that all the matters be taken up by the same secretary.
Much obliged.
This matter is to be heard along with WPS number sentences.
Item 8, WPS 5761 of 2023.
This petitioner.
The matter relates to pensionary benefits to the petitioner, who was appointed in the year 1980 in the government-aided minority affiliated commissioner And he superannuated in the year
Why are you
2007
not
itself.
complying with the earlier orders?
We have given the funds to the university because that's their investment.
Where is the university?
University have to, but
What are you doing with the funds?
funds have been dispersed to most of the teachers. So far as this
So
petitioner
you
is
seek instructions?
yes, and notices would go to respondent number 5.
Who is responding?
Principal Parambir Alpha.
It was the principal of the college who was supposed to forward
Yes,
the claim.
yes, please.
I
Along
have
with-
stated in my writ petition that he has forwarded the claim, however, the
So
notice was
notice
not
is
made.
required.
Yes, yes.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that the matter relates to post-retirement benefits. The petitioner was working in a minority institution represented by respondent number 5.
Government aided minor.
That is respondent number 5. A government aided minority institution. The learned counsel for the state submits that a counter affidavit has been filed stating that the required fund for payment of retirement benefits for all the concerned teachers or staff has been forwarded to the university, and it is for the university to take care of disbursement regarding each of the persons. The learned counsel for the university has submitted that the question of disbursement to the petitioner would arise only when the details are furnished by respondent number 5. However, he is not aware as to whether any step has been taken to make payment to the petitioner or not. How many petitioners are there?
Only one petition.
Only one.
In para 13 of my writ
Issue
petition,
notice to respondent number 5. You will serve Dasti.
दस्ती में difficult हो जाएगा.
Okay. Issue notice to respondent number 5 through ordinary process as well as through speed post. For which the requisites be filed by day after tomorrow. You don't want retirement benefits?
No, I want my lord. She is an aged lady, that's why.
You
She
have to
retired in
do it.
2007 minutes.
She retired in 2007.
You have to do it, no? You don't need the lady to come and help you in filing the requisites, right? Requisites by day after tomorrow. Office is directed to track the speed post delivery and prepare appropriate office note with regard to service of notice. The respondent university is also directed to seek instructions and file a counter affidavit with regard to the status of payment to the petitioner. Let the matter be listed on 6th of March, 13th of March 2023. Pendency of this case will not be an impediment in release of retirement benefits to the petitioner.
Much
Item 9, WPS 5783 of 2023.
In this case, now the petitioner claiming the post of in charge of the principal on the basis of the specific direction given by the district education officer also. Then extra 5 words.
Do you have a remedy under JET?
Yes,
Yes.
under section 8.
This is not maintainable. Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has raised a preliminary objection with regard to maintainability of the present writ petition by submitting that the petitioner has an appropriate, efficacious remedy before Jharkhand Education Tribunal
Under section 8,
under section 8 of Jharkhand Education
Tribunal Act 2005.
Tribunal Act 2005. The counsel for the petitioner does not dispute the availability of alternative remedy under JAT, but submits that the present petition be entered into. After hearing the learned counsel for the parties and considering the nature of dispute involved in the present case, this court is not inclined to entertain this petition on account of availability of efficacious alternative remedy to the petitioner before Jharkhand Education. Accordingly, this writ petition is disposed of, enabling the petitioner to avail the alternative remedy within a period of 15 days from today. 15 days from today.
Item 10, the nucleus double 619 of 2023.
Just a minute. Who is for the respondents? The learned counsel for the petitioner is present. Nobody appears on behalf of the respondents. Upon perusal of records, this court is of the view that a counter affidavit is required to be filed by the respondents.
I would have a hearing.
You are hearing. How much time do you need to file?
3 weeks.
Absence but the learned counsel appearing on behalf of the respondents prays for and is granted time till 27th of February 2023 to file a counter affidavit in the present case. Rejoinder, if any, by 5th of March. Post this case on 6th of March 24 under the heading for admission. All the cases of fresh filing after notice will come under the heading for admission. Even if I have not dictated, ensure that it will come under the heading for admission.
Item 11, the nucleus double 688 of 2023.
Counter will be required in this case.
What counter?
Okay, the petitioner has prayed for confirmation of his first time bond promotion and also the mandamus.
That issue has already been decided by the learned single judge.
Lordship, he has also prayed for third modified assured career progression. The second
You file your
previous-
counter affidavit. And admissible dues you pay, right? WPS number 6688 of 2023. The learned counsel for the parties are present. The learned counsel for the respondents prays for and is granted time till 16th of February 24 to file a counter affidavit in the present case. Rejoinder, if any, by 23rd of February. Post this case under the heading for admission on 6th of March 2024. At this, counsel for the petitioner has referred to order dated 29/9/2020, passed in WPS number 873 of 2023, in which the petitioner was amongst the petitioners of the said case.
Cancellation of first ACP was considered.
The learned counsel submits that the consequential benefits arising out of the said order has also not been given to the petitioner so far. Subject to filing of counter affidavit, the admissible amount be paid to the petitioner prior to the next date.
From daily list to orders, item 32, WPS 7232 of 2023.
Who is for the petitioner? Pass over. इसी में वो ऑर्डर लगेगा पैरा टीचर का.
Item For case filing item 33, WPS 3644 of 2023.
Yes.
So
Sorry?
I am not ready, Lordship, because just I will.
Counsel for the petitioner submits that he is not ready with the case. Post this case tomorrow.
Counter will you
No counter can be directed without hearing you. You come ready tomorrow. Where are the bail orders? Where are the conditions? कुछ नहीं.
नेक्स्ट वीक हो सके तो कर दीजिए.
No. I posted it tomorrow.
हमको थोड़ा शादी में जाना है, कोई बात नहीं. खाली कल नेक्स्ट वीक कोई डेट रखिए अगर पॉसिबल है, नहीं तो फिर तो हम रहेंगे.
On next Tuesday, under the same heading.
Item 34, WPS 3700 of 2023.
This petitioner.
Application for direction to respondent number 6 and 7 to pay revised pensionary benefit amount from the month of February 2007, treating the petitioner as superannuated on 31/8/2007. Earlier, the petitioner was retired.
Where is the respondent?
6 and 7 is CMPF.
CM?
Coal Mines Provident Fund.
Coal Mine Provident Fund. So why BCCL is made a party?
Because I am the employee of BCCL. I was retired from BCCL.
Who is for appearing for CMPF?
Mr. Prashant Singh.
Where is he? Okay, you both of you file complaint. The learned counsel for the parties are present. The learned counsel for the petitioner submits that in spite of the fact that an order dated 5/11/2012 was passed by this court in WPS number 2108 of 2004. The date of superannuation of the petitioner has not been treated to be 31st of January 2007. यही आपका
उस पीरियड का जो डिडक्शन है BCCL will have to forward to CMP.
Yes, the learned counsel submits that the contribution of Provident Fund is required to be forwarded by the employer BCCL to Coal Mines Provident Fund, and the amount is to be remitted to the petitioner by Coal Mines Provident Fund, right?
No, he will get enhanced pension. If we deposit the amount, his pension would be enhanced to some extent. Now he's getting pension, it would be enhanced further.
Exactly. The amount is to be remitted by the employer BCCL, and upon such remittance, the petitioner would be entitled for enhanced pension, to which is being paid, which is already being enhanced pension. However, the petitioner is receiving pension at a lower rate by Coal Mines Provident Fund. The counsel for the respondent BCCL as well as Coal CMPF are directed to seek instructions and file a counter affidavit in the present case, which should be filed by 23rd of February 24. Post this case on 5th of March 2024. Pendency of this case will not be an impediment in on the part of the respondents to comply with their statutory obligations.
Item 35, WPS 5790 of 2023.
Yes, petitioner.
So the petitioner has prayed for quashing of
What is
election.
the status of LPA number 5119 of 2022?
So that will have to seek instruction because that
What
is a simple.
instructions? For
Similarly,
this also you need to seek instructions.
Lordship, I have
आप
to-
बताइए जरा status क्या है? Status
Those
of
filed this year.
LPA against RIT 5119 of
That is
2022.
Annexure 12.
0.11.
हाँ, इसका status बताइए कोई LPA फाइल नहीं? नहीं? Your case is covered by this.
My case is entirely covered. Same notification is under challenge. Only my name was there in that notification, which was quashed by the Honorable Court, which was interfered with by the Honorable Court.
The learned counsel for the petitioner is present. Nobody appears on behalf of the respondents. The learned counsel for the petitioner has submitted that the case of the petitioner is squarely covered by order dated 29/2023 passed in WPS number 5119 of 2022. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 16th of February 2023. Post this case on 20th of February 2023 under the heading for admission. Since nobody is appearing for the respondents, let a copy of this order be forwarded to the respondent number 2. Office is directed to forward a copy of this order to respondent number 2 for compliance.
Public.
Item 36, WPS 5802 of 2023.
Yes, petitioner.
She is the widow of the ex-employee and he was appointed as a lecturer in Gosford College, again minority institution in India. And my prayer was for pension and gratuity along with the statutory interest. Not 3 cases were filed altogether. In one of the matters, there was a direction to file a representation and the matter has to be disposed of. After disposal of that matter, even my pension and gratuity has been released upon me. My husband died in the year.
So that has been released.
That have been released. Now only grievance that is left at present is the statutory interest that would have accrued right from 2013 when my husband expired. That has not been paid.
2013 to?
2013 to
When
the
was
date
it
of
released?
payment. Milord, the statement I have written, exact date has not been mentioned. Milord. It is mentioned in paragraph 11, page 8.
Where is WPS number 3520? It was filed by somebody else.
Yes, ma'am. Order is here.
Where is that? Where is the order? There was a direction to pay with statutory interest.
उसमें तो सिर्फ 7th के revision को include करते हुए pay करने का था. But gratuity, payment of gratuity act में Milord statutory interest has been included.
As on date, Milord, none of the retired teachers. Here is a case of pension of minority affiliated colleges. Milord, the employees retired in 2007. The decision of the Supreme Court came in 2020. Milord, the state government and university are making payment of arrears from the date of retirement, that is long 15 years. When they retired, they knew that it is not a pensionable service. However, by a judgment of this court, now they are getting pension along with arrears from long 20 years. And huge amount of money is being paid as arrears amount. So, Milord, in none of the cases till date, any of the courts have passed orders for payment of interest on the dues.
So the issue got settled much later.
Much later, in 2020-21.
Where are those judgments?
Ma'am, just before this, the case I had argued,
Yes.
the judgment is there in that file. If I may kindly be part of that.
In 2020-21, the SLP got dismissed of the state of Jharkhand. Thereafter, the state government took a policy decision that we would comply with these orders. Thereafter, the funds have been released to the
Prior to that, nobody was getting.
Nobody was getting. They retired, they knew that our services are not pensionable.
Then what was the cause of action to file those cases?
Because the state government took a decision that after a cut-off date, those appointed up to 2004, we will be giving pension to them, not to the earlier. The court held that you cannot discriminate on the date of retirement. So if anybody has retired from any of the minority affiliated colleges, they are bound to get pension along with its areas.
So at the time of entry of their services, they knew that
it is not a pensionable service.
My lord, there was a resolution in the year 80 itself that the pension has to be paid. Those who have retired at the time
in
of
that order,
resolution
is there
paid.
any direction to make payment with interest by the Supreme Court?
My lord, may I bring that?
You just bring it.
SLP
Pass
is
over.
dismissed.
No, you get the order of this court and tell us if there is any direction for payment of gratuity with interest to any of the employees. We will go by that one.
Page 15 of this minute now, we have sanctioned the pension in 2010-20 and we have paid the whole amount of areas. It is every.
Get the orders, please. You were a party in that LPA?
No, we were not party in that LPA, but the law has been settled. They
That's
came
right.
up with a resolution.
You never had that grievance against the resolution. You are wanting to take a benefit out of the judgment which
That
has
has
been
come.
passed.
Yes.
There is no problem about it.
Yes, yes.
Perfectly all right. But you did not file any such case.
No.
No problem.
It was mentioned in the LP
We'll
that
see
the
that.
judgment is not judgment in personam, it is judgment in rem, and it
That's
has to be applicable to all
That's
the
right.
employees. who
Therefore,
super
all the
advocate.
employees, whatsoever benefit they were getting out of that judgment, you will only get that. Nothing more. Get that.
Next case is also the same case.
Okay, sir. You get both of them. The matters are being passed over. We'll take up the Passover matters at 12 o'clock.
37.
37 is also the same, no?
Yes.
That's true.
Item 38, WPS 5821 of 2023.
Yes, petitioner.
There are two petitioners. They have filed an this writ petition for direction upon the respondents to consider the application filed by them for inter-district mutual transfer.
Is there any provision?
Yes, ma'am. That is an
You are covered by that provision?
Yes, गंभीर विशेष परिस्थिति में हम लोग भी आते हैं.
What is that गंभीर विशेष परिस्थिति?
I am working, one of petitioner number 1, he is working at Dhanbad as an assistant teacher. His home is at Hazaribagh. Petitioner number 2, he is working at Hazaribagh. His hometown is at Dhanbad. He is also working as an assistant teacher. Both of them, they have to look after their old parents. And weekly, they have to go to their hometown.
Whom have you represented?
I have represented the concerned authority to take decision is director of the primary education.
Where is that representation before the director?
Yes.
And when did you file it?
Yes, I have filed on 9/2/2023.
Where is that representation?
Yes, ma'am. That representation, Annexer 4 series, relevant page is marked of petitioner number.
Series?
Yes, Annexer 4 series.
You have filed repeated representation.
Before the secretary, before the director, before the
Who is the competent?
Competent authority as per the circular is director. That is at page 45, ma'am. Is the director petitioner number 1 on 9/2/2023 and petitioner number 2 also on 9/2/2023 before the director. Same day they both of them were filed. That is at page 49, petitioner number 2.
49 is petitioner number 2.
And 45 is petitioner number 1.
45 is petitioner number
1.
1. So you are claiming as per their own rules, regulations?
Yes, a circular issued by the Primary Education and Literacy Department, that is at page Annexer 3 series. The relevant part is at page 27.
27?
Yes, page 27 is the circular of the government. The 6 Kh Roman 4 page 27 6 Kh Roman 4 सभी संवर्ग के असाध्य रोग दिव्यांग महिला शिक्षक एवं अन्य गंभीर परिस्थितियों वाले मामले में उनके आरक्षण कोटि वेतनमान विषय जो उनके मामले में लागू हैं के अनुसार अपने संवर्ग में पारस्परिक स्थानांतरण.
This is read with the clause 8. Is it read with clause 8 at page 30?
Page 30. Page 30 मतलब
अंतर जिला स्थानांतरण.
अंतर जिला स्थान, but that is पारस्परिक स्थानांतरण. पारस्परिक मतलब mutual. The word is पारस्परिक.
This is also mutual.
Mutual.
Your case is also
अंतर
mutual.
जिला means one petitioner is say a single petitioner is coming and praying that I may be transferred to another district. But this is there are two petitioners. They are praying for a mutual transfer. So पारस्परिक स्थानांतरण and the competent authority is the director who can take
This is पारस्परिक स्थानांतरण is mentioned where?
Where मतलब रोमन
पारस्परिक.
पारस्परिक स्थानांतरण के संबंध में संबंधित निदेशक
That's right.
द्वारा विचार कर निर्णय के परंतु इसका अधिकार पूर्ण दावा नहीं है. That is only a.
You just want a consideration.
Yes, under a consideration.
When did you file that?
On 9/2/2023.
9/2/23 you made your
Representation.
by post.
By post. Speed post.
Ladyship, their application is already under consideration. According to the RTI, reply to the RTI
Okay.
Act
It is under consideration by the director.
by the director. The public information officer has.
So expedite it.
Please.
Right? Okay. Learned counsel for the petitioners are present. The learned counsel for the learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioners has submitted that petitioner number 1 and 2 are working as para teacher,
As an assistant teacher.
as assistant teacher in 2 different districts, and therefore they have applied for mutual transfer before the director secondary education, primary education,
Primary education.
director of primary education. Respondent number?
Respondent number 2.
Respondent number 2. He submits that such application has been filed in terms of the regulation,
Circular.
in terms of the circular framed by the state of Jharkhand as contained in Annexure 3 series. He refers to clause 6 thereof. The learned counsel submits that both the petitioners are required to take care of their old parents in their in the concerned districts to which they belong, but their posting being their appointment having been done in other district, they are not able to discharge their obligation towards parents. The learned counsel for the respondents has submitted that the matter of mutual transfer for which application has been recently filed on 9/2/2023 as annexed in the writ petition is pending consideration before the respondent number 2. He is not aware as to whether any final decision has been taken so far.
We'll have to seek instruction.
That's it, no problem. Considering the nature of relief sought for by the petitioner, this court finds that there is a provision for mutual transfer as per clause 6 of the circular referred to in annexure 3 of the writ petition, but the petitioners cannot claim it as a matter of right. However, the discretion is with the respondent number 2 to take a decision. Since no decision in the matter has been brought on record by the other parties, and this court has not called for any counter affidavit from the side of the respondents, and it appears that the matter is pending consideration as per the records available. This writ petition is disposed of, directing the respondent number 2 to expeditiously take a decision in the matter of mutual transfer with not later than 15 days from the date of receipt of a copy of his order along with a copy of the writ records. If the decision has already been taken, no fresh decision is required to be taken. Only a copy of the decision so taken be forwarded to the petitioners through speed post. This petition is accordingly disposed.
Appearance दीजिए.
Item 39, WPS 5822 of 2023.
Yes, petitioner.
So this matter relates to the promotion. Petitioner was appointed on 7/1/2000 by virtue of the national one as a plant protection supervisor.
You filed a counter?
No, Lordship.
File it.
I seek instruction to file counter.
This is what I'm saying.
Yes, yes.
Learned counsel for the parties are present. The learned counsel for the respondents pray for and is granted time till 23rd of February 24 to seek instructions and file a counter affidavit in the present case. Rejoinder, if any, by 4th of March. Post this case on 6th of March under the heading for admission.
Item 40, WPS 5826 of 2023.
Yes, petition.
Lord, this is a matter of promotion and I need short pass on the
Counter file. Good. Same order.
Item 41,
Give your
WPS
appearances,
5822 of
please.
2023.
What is the matter?
It is a matter related to appointment.
Same order.
Appearance दीजिए.
Item 42, WPS 5833 of 2023.
Yes, petitioner. Who is for the petitioner?
AK Tiwari is being shown minutes. In this case, we have received instructions, my lords. We'll be filing the same by tomorrow. It may be taken up in next week.
All right. The learned counsel for the petitioner is absent. Counsel for the petitioner submits that he has received instructions to file a. Not required. Counsel for the parties are present. Learned counsel for the respondent RIMS.
Well, I'm for the statement.
Respondent state submits that he has received instructions to file a counter affidavit in the present case, which will be filed by Monday.
Yes.
By Monday. Post this case on next Wednesday under the heading
Not
for
after
admission.
1 week, not so that if reply is required, I will file it.
Not required, we will see that. Let the matter come. What about this, you are for the state, what
Yes.
about RIMS?
RIMS has not been made.
In this case,
It's a matter, well, appointment rules is to be framed in consultation with the finance department.
Appointment rule will not as per as.
And it is in the process of framing rules, my lords, and
Okay, next Wednesday. Under the heading for admission. Just a moment. Next Wednesday under the same heading. Just Wednesday is a holiday. Next Tuesday. Monday को file कर देंगे. Next Tuesday को under the same. It will come for fresh filing. Since you have said that it is in the process of being framed, so it can be disposed of.
what instruction they have provided, that they are in the under process of framing the entire rules in consultation with the finance department.
That's right.
And after framing of that rules, they'll be completing the process. of appointment.
There are 2-3-fold prayer in the resolution.
We'll see that.
Item 43, WPS 5834 of 2023.
Yes, petitioner.
The petitioners
we herein pray for a direction, particularly on respondent number 2, to grant them promotion on the post of superintending engineer with retrospective effect from the date they are eligible in terms of annexure 2 and annexure 5. These are two important resolutions, Your Lordship.
You can't get promotion from a retrospective date.
Your Lordship, there is a notification to that effect.
That you will get it?
Yes, Your Lordship.
Where is that notification?
Yes, annexure 5.
Page number?
Page number 71 starts from 71. Relevant is at page 72. Your Lordship, if I may just briefly state the facts as to what happened and why this retrospective effect came.
See, when they have taken a decision, we don't need to bother.
Yes,
Right?
Your Lordship. My case is that I am eligible since 2019. I have made representations, but till the date, they are not taking any decisions and they are putting persons on additional charges on superior post, and that is why regular promotions are not taking place. Now the rule says that they have to conduct conduct DPC twice a year. They have to prepare the panel list in the month of December of the preceding year, and on the
You are
basis of
teachers?
no, Your Lordship. We are engineers.
So your seniority list has been finalized?
Yes.
Where is the seniority list? Any junior has been, you have been promoted, not promoted?
Not promoted.
Okay. Any junior has been promoted?
Your Lordship, my juniors have been given additional charge on the higher.
That is additional charge, no, you cannot crib about.
Yes, I'm not cribbing about, Your Lordship, but I'm saying that since there is a process of regular promotion for
Your
all the employees.
juniors have not been promoted.
Not promoted.
So they will consider as and when they want to. Why should we?
Your Lordship, this has been kept pending for years. Now I'm at all the petitioners are at the verge of retirement, superannuation, Your Lordship, and they are kept on the same on the post of assistant engineers, and thereafter they have not received any promotion. Now the rule itself is very clear from 2003, which was also clarified in 2014, subsequently in 2022 and 23. But they are not taking any action, and that is why these petitioners have approached this Honorable Court.
When did you become eligible?
I became eligible in terms of annexure 2 series. Firstly, since I became eligible on in terms of clause 2,
You tell us when did you become eligible?
I became eligible on 25/9/2018.
What is the vacancy position?
Your Lordship,
And since then there is no DPC held.
no DPC is being held.
From where do I get this?
Your
That
Lordship,
since
I have made a
2018,
specific government.
You were eligible from 25/9/2018. First show me that,
Yes.
and show me that since then no DPC has been held.
Yes. Your Lordship, kindly.
25/9/2018 is an notification
Yes.
Dated at annexure 1.
Yes.
What is this
no,
notification about?
25/9/2017.
2018.
2018. Then I become eligible on 25/9/2019. 1 year I complete on that post. Annexure 1 is the
You
promotion.
become eligible for promotion upon completion of 1 year.
1 year in the on that particular post, along with if I have completed 20 years of service as a government employee.
You have done it?
Yes, appointment in the year 1987 itself. There is so it is an admitted fact. Annexure 1 is
Counter affidavit has been filed.
no.
How do you say admitted?
Yes.
How do you say admitted?
Lordship, it is appointment and on the
Where are
basis
the
of
promotion rules?
Promotion rules. Yes, I have annexed the promotion rules. Your Lordship, annexure 2 series. I'll just point out 4 points from this annexure 2 series. First is at page number 30. The very first point, if I may be permitted to place that.
Page number 30.
Page number 30.
Okay. Day before yesterday, we have passed one order, maybe yesterday, regarding grant of promotion and Kalavati.
I'm not aware. I'll look for that.
Who was there? I don't remember. The order may be uploaded today itself, right?
Your Lordship, what I'm praying is that Annexure 6 are my representations given time from time to time. Let them consider and pass a proper order to that effect as to why they are not giving me promotion, because they have no reason for not giving me promotion. They have.
You will get a better order.
Yes,
So
yes.
just let me just see. Yesterday, who was there? You were there, Mr. Rupesh? आप कौन सा ऑर्डर एक किए थे प्रमोशन वाला? Who was it there? Sorry. नहीं, क्या नाम है? समीर सॉर्डर was it there? उनसे पूछ के आइए, केस नंबर लेके आइए. सेकंड हाफ में आइए. या कल आइए, tomorrow.
Tomorrow. Okay.
Post this case tomorrow. Under the same meeting.
Passover case from supplementary list item 1, WPS 212 of 2023.
Give me the list of dates. List of dates.
In 1971, petitioner was appointed on the post of Sipahi, posted in CRPF at Haiyor.
When did he?
My lord,
He absented from few days.
He was ill since from 1982. He was 1982 he was ill and he was examined by the Silchar hospital, and thereafter again he joined in duty during 82. And in the year of 1984 he came to his native place on
No,
leave.
you were absent from 4/5/83 to 26/5/84. This is the statement you had given in the first half. Now your statement is changing. He remained absent from 4/5/1983 to 26/5/1984.
380 days, that is the that is my prayer for
380
passing.
days. When did you resign?
My lord, actual date which has not come, but from the counter affidavit of earlier writ petition, it has reflected.
Please don't refer to anything.
My lord, since
Date of resignation.
Date of resignation, it has come from
It's
the
not
counter.
there in the record. We will not bother to see other petitions. Date of resignation is not there. When was it accepted, according to you?
26/5/1984.
From where do you say this?
Again, I'm saying, my lord, from the counter affidavit.
No. We can't. You see, you have to make out your own case.
Yes, let me allow.
No, we will not allow you to refer to any further.
Yes,
You just
yes.
tell us when was your resignation accepted.
My lord, just a moment. Prior to this inquiry, my lord, I am submitting one thing, that this writ petition has been filed. Since earlier writ petition was filed, by the petitioner has been withdrawn, even the counter affidavit, the order of dismissal was there. That has not been challenged. And that order of dismissal never been communicated. It has come only in the counter affidavit. And in the counter affidavit, it has reflected in paragraph 29 that his resignation was accepted 26/5/1984.
What is the order of dismissal?
Order of dismissal, yeah, page 27 का.
Date.
As a result of judicial trial conducted of Sri Jai. Date है 5 जून 1984. 5/6/1980. इसमें सिर्फ इसमें इतना ही बोला जा रहा है कि विल्सन वार्ला is dismissed from service with effect from 5/6/1980 from that.
When were you convicted? When were you convicted?
I convicted on the on the same convicted on the same date only.
Where is the order of conviction?
Order of conviction.
We will not entertain your writ petition challenging the order of dismissal way back in the year 1984.
Because here is a cause of action is continued in view of
Did you work thereafter? After 1984, did they take back your work? Did they take you back?
No.
Did you continue to work?
No.
Then what were you doing from 1984? They never took you back in service.
My prayer is not to the extent. My prayer is only that I have discharged more than 10 years. I am entitled to get pension, benefit and gratuity.
In spite of your conviction.
That the conviction which is my case is that my resignation has been accepted, and thereafter, my lord, this conviction has been done, and that is ex parte order. That is not the not
What
in my
is ex parte?
Ex parte order. The order of conviction is ex parte order.
Where is that?
Yes.
From where are you giving this fact that it is an ex parte order? Have you say
No.
anything beyond the records?
Not beyond that. From the record.
Which record?
Therefore, I obtain the entire certified copy of the counter. From the counter, my lord, the order of dismissal and the conviction is also annexed.
Very good.
Since after filing this writ application, it was come, therefore it could not be annexed. And in my prayer portion, I have also mentioned this fact, and in the writ petition also, that the order of conviction is ex parte.
So what? Ex parte order is not an order.
Here, my lord, in the year of 1984.
Was it ever challenged?
Yes, it was.
You challenged the order of conviction.
It was never been communicated. That is my case.
Oh, you are not aware that you have been convicted?
Why is the writ petition?
Are you not aware that you have been convicted?
As and when I came to know from the counter, immediately I challenged.
You came to know about your conviction from the counter affidavit?
Yes, ma'am.
Very good.
That is the case, ma'am. That's why I.
Where have you stated? In your writ petition that you came to know about the conviction in the counter affidavit?
Yes, I have stated. Para 12.
No, you simply say that you have been dismissed, so you came to know through that.
No, the petitioner humbly stated the order dated so and so, though he has been dismissed from service, he has never been communicated to him, only he came to know about the same from the counter affidavit.
That is a dismissal order. Conviction order is a separate order.
Dismissal order is only because of the conviction.
Conviction order is a separate order, no?
Conviction
Conviction order must be a separate order.
That is the order passed by the judicial magistrate,
So?
probably.
And you are not aware about your conviction?
Because ex parte order, my lord, that is ex parte order.
I do not.
और
What order?
CRPF ऑफिस ये तो गांव में देहात ये तो ओवर स्टेट है वो तो कभी गया ही नहीं वहाँ.
Very good.
एक बार हुजूर देख लो.
कुछ नहीं देखना है. इतना पुराना ऑर्डर.
हुजूर अगर बोलेंगे तो हम लगा देंगे सर.
Nothing.
लाना तो
You have received the amount of GPF?
Only 3,000.
When?
हाँ.
Six.
2006 के बाद एक रीट फाइल हुआ था उसमें रिप्रेजेंटेशन डिस्पोजल का ऑर्डर हुआ था उसी.
And what did you do after 2006?
Thereafter, my lord, he made several communications, but no order has been communicated. And in second writ petition was filed, that is 2017, and that has been withdrawn. And in their counter everything has come.
Where is it mentioned in the earlier counter affidavit that your resignation was duly accepted by the competent authority?
Paragraph 29 it was given. In the middle portion, it is evident to us. It is evident that when his resignation was not accepted and he did not report to the unit immediately and had reported at his own on 26/5/84. AN headquarter, BN CRE Silchar.
Where is it that it was duly accepted by the competent authority? You said that in the counter affidavit it has come that prior to dismissal, your resignation was duly accepted.
The case of the
I just want to know from you to substantiate your statement made just now. You can argue anything.
No,
Then
how can it is evident
this
that
amounts to,
Yes.
very serious misconduct.
Yes.
Should I initiate a proceeding against you?
हम
Should I initiate a
इसका
proceeding
मतलब
against
हम
you?
यही समझे हम
कि
बताना चाहते
Then
हैं
you do not know English also. Yes? Okay.
it is denied, but here only
WPS number 212 of 2023. Heard the learned counsel for the parties on the merits of the writ petition. This writ petition has been filed for the following relief. The learned counsel for the petitioner has been specifically asked by this court as to why the writ petition has been filed on 17/1/2023, challenging the order dated 5/6/1984, whereby the petitioner was dismissed. The learned counsel for the petitioner has submitted that he was not aware about the fact that the petitioner has been dismissed from service. While giving the foundational facts, the learned counsel submits that the petitioner had joined CRPF as back as in the year 1971, whereby he was appointed as a Sepoy. He further submits that the petitioner had absented from duty from 4/5/1983 to 26/5/1984. That is a total of 380 days, which was the reason for his dismissal from service. The learned counsel has also submitted that the petitioner had resigned from service way back in the year 1984, and his resignation was also accepted. But in spite of, this is what you have submitted, but in spite of acceptance of,
That is not accepted.
no submission to this effect,
No.
the learned counsel has submitted that the petitioner came to know about his dismissal from service only through the counter affidavit filed by the respondents being WPS number 902 of 2017, when he had filed a petition for release of his pension on account of completion of 10 years of service. And according to him, he has completed 10 years of pensionable service. The learned counsel has submitted that GPF amount of rupees 3,333 was paid to the petitioner pursuant to, way back in the year 2006, pursuant to order dated 31/10/2006 passed in WPS number 4289 of 2006. But pension has not been paid. The Learned Counsel has, upon a query of this court, the Learned Counsel has also submitted that after 26/5/1984, the petitioner never joined his duty. Correct? And accordingly, he did not work with the respondents after 26/5/1984. The Learned Counsel for the respondents has opposed the prayer of the petitioner and has submitted that order of dismissal has been challenged. Order of dismissal was passed way back in the year 1984 and it has been challenged in the year 2023. And the petitioner was actually convicted, which was the reason for order of his dismissal. The Learned Counsel submits that the petitioner, having been convicted, he is not entitled for pension. After hearing the Learned Counsel for the parties, this court finds that the order of dismissal of the petitioner was passed on 5th of June 1984 as contained in Annexure 2 to the writ petition, which reflects that the petitioner was dismissed from service as a result of judicial trial conducted by Judicial Magistrate Class 1 and Assistant Commanded 33 BN CRPF Azawal under Section 10 within bracket M of CRPF under the provisions of CRPF Act 1949. And the petitioner was also sentenced to undergo simple imprisonment. The impugned order also reflects that from the date of conviction under Section 12(1) of CRPF, all medals and decorations earned by him during service, if any, also stood forfeited. The impugned order also reflects that the petitioner had remained illegally absent during the period from 4/5/1983 to 26/5/1984 and the said and had remained in custody during the period from 27/5/1984 to 5/6/1984 and such period has been directed to be treated as diastema. It has also been mentioned that the petitioner would not be entitled to any pay and allowances or any other service benefits for the said period of absence. Considering the fact that the petitioner never joined duty after 26/5/1984, the argument of the petitioner that he had no knowledge about his order of dismissal passed way back on 5/6/1984 is not acceptable. From the records of this case, it appears that the petitioner has tried to make out a case that the petitioner had resigned from service, but neither the date of resignation has been mentioned, nor the resignation letter has been annexed, nor there is any material brought on record by the petitioner regarding acceptance of his resignation letter. And accordingly, the said plea of the petitioner is not acceptable to this court. The fact that the petitioner has been convicted has also not been disputed by the petitioner in the writ petition. Considering the totality of facts and circumstances of this case, there is no merit in this writ petition. The fact remains that there is no justification. The fact also remains that there is no cogent explanation for delay in challenging the order of dismissal passed way back as on 5/6/1984. Accordingly, the present writ petition is dismissed.
First case from Delhi list item 32, the look is 7232 of 2023.
For the petitioner.
Dear my lord,
I have seen your prayer. You have seen this order? LPA number 50510 of 2023. Have you seen this? So same order should be passed.
Same order, my lord. Following
We
that
only
very
with
order-
respect to petitioner number 8. So far as other petitioners are concerned, they had moved this court earlier. They were called for counselling.
They were called for counselling.
And therefore, by virtue of this order, they are not entitled to any.
My lord,
This is what division bench order we have passed.
Yes.
You challenge it, we can't do anything. The persons who have been called for counselling, once they are not entitled to second
yes,
counselling.
madam. The specific environment has been made, my lord, although they have been called for the counselling, but only their names were
No,
written
we
in the
cannot
register
enter into such
and no
roving
order
inquiry.
has been passed.
We cannot enter into such kind of roving inquiry. The KWPS number 7232 of 2023. Learned counsel for the parties are present. This writ petition has
एक
been
बात को
filed for
consider
the
कर लिया
following
जाए
relief. सब consider करेंगे. क्या
थोड़ा
करेंगे?
देख लिया जाए, थोड़ा मेरा सबमिशन सुन लिया जाए.
You just tell what
Madam.
all submissions you want to be recorded.
Yes.
Tell
My
us.
lord, in the para 2 in the main petition, my lord, I have stated that some of the petitioner had moved.
Only
yes.
no, not some. Right?
My lord, in
Out of 8 petitioners,
My lord.
you have said that out of 10 petitioners, you have said that 9 had moved.
पैरा 5 में उसका स्पेसिफिक दिए हैं, सप्लीमेंट्री में उसको स्पेसिफाई कर दिए हैं, मतलब सप्लीमेंट्री दैट द पेटिशनर नंबर 1 निरंजन कुमार, पेटिशनर नंबर 2
I've read it. You
Yes.
think I have not read it?
So, my lord, thereafter, my lord, a specific averment I have made, my lord, that the respondent in compliance of the order passed in WPS number 2658 of 2019 called the aforesaid petitioner in the office of the Deputy Superintendent of Police of the District Education Officer from the district of Ramgarh, Jamtara and Dhanbad only. Rest of the district, nothing was done. Accordingly, the petitioner number such and such जिनका है वो सारे went to the offices of the aforesaid respondent. Their signature were obtained in the register, but as a matter of fact, no counselling was held, and even the document were not verified, and even no communication has been made to the petitioner in writing. Only authorities concerned have orally said them that their candidature cannot be considered in the non-para category since they belong to para-teacher category. Now, my lord, in view of the division bench, my lord, when this order was passed, this division bench order of the LPA number 2003-2020 and the analogous LPA was not there, my lord. Now, therefore, my lord, in view of this subsequent development, the order passed, my lord. For that, my lord, the statement has been made at paragraph 8, my lord. Permit me to place, my lord.
Yes.
That the petitioner
Just
had
a
filed
moment.
the
You are all non-para teachers applied under non-para.
Yes.
Non-para category.
all were para teachers. They applied Yes.
WPS number 7232 of 2023, heard the learned counsel for the parties. The learned counsel for the petitioner submits that the petitioners before this court were para teachers and they had applied under non-para category.
No, para teacher should say.
Applied under para teacher.
Para teacher. उसमें क्या हुआ था कि पैरा टीचर में अप्लाई करने का कंडीशन था, लेकिन बाद में जो 50% जो पोस्ट था नॉन पैरा कैटेगरी में जो ओपन टू ऑल था, तो बाद में हुआ कि जो ओपन टू ऑल वाला कैटेगरी जो जनरल कैंडिडेट है वो कम नंबर में भी सेलेक्ट हो गए, बट being the para teacher category we have secured more marks than the candidate who have been selected, and the post in the non para teacher category are still vacant. So हमारा
no, you apply, you were para teacher and you had applied under
para teacher.
Then your candidature cannot be considered under non-para category.
That is the judgment passed in the LPA, my lord. कि no, वही तो उसको किया गया कि वो open to, that is the LPA number, my lord. That is the order of the LPA.
Para teacher category, they opted for reservation.
My lord.
Their candidature can be considered under para teacher category if they apply under para teacher category. But if the para teacher category they apply under non-para category, then their candidature cannot be rejected.
But this was the issue in these analogous LPA.
You tell us, you show me one judgment of any court, of this court's division benches.
तो वही सारा चीज दिए।
नहीं कहाँ दिए हैं?
ये LPA जो जितना हम डिस्कस किए हैं।
Discuss. You just produce a copy of the order.
हाँ, copy produce कर देंगे।
Okay. The learned counsel for the parties are present. The counsel for the petitioner has submitted that the petitioners are para teachers.
Yes.
They had applied under para teacher category.
Yes.
But their candidature should have been considered under non-para category.
Yes.
He submits that there are judgments passed by honorable division bench. बताइए which LPA?
LPA number 203/220 मतलब all these LPA मतलब दीजिए।
You just tell us one judgment where their candidature has to be considered under non-para category.
वो एनालोगस केसेस में ही है।
You just tell us. You say so many orders.
हम बता रहे हैं, हम इसमें
Mr. Singh, please appreciate. You show me one judgment. I don't need number of judgments, right? The counsel for the petitioner has submitted that there is judgment passed by honorable division bench
that the bench of the single judge. चूंकि ये 203
आप ही लिखा दीजिए order, that would be better.
हम point out
You dictate the order.
assist कर दे रहे हैं हुजूर को कि perfect.
You are assisting this court without the order. I don't know what kind of assistance is that. We will not see your tab, right?
तो हुजूर के पास भी है, मतलब मिल जाएगा।
We do not.
दिया जाने दे देंगे।
We do not know. You don't even know the case number.
अच्छा तो हम दे देते हैं, निकाल के दे देंगे।
Bring it in the second half.
हाँ, second half।
ले।
बड़ी मोटा है, सब निकाल के देना पड़ेगा। अगले सप्ताह में रख लिया जाए।
नहीं अगला हफ्ता नहीं, अगला हफ्ता तक तो काउंसलिंग हो जाएगा, एक ही बार काउंसलिंग होने वाला है।
वो आ जाएगा।
It is not in your interest.
हाई कोर्ट में आ गए हैं, इनको मौका मिल जाएगा।
नहीं मिलेगा।
हम इसको
नहीं। No. If you are able to produce it, you produce it.
हाँ, प्रोड्यूस कर देंगे, पैसा मेरे पैकेट से लग जाएगा। ऐसे क्लाइंट आता है तो बोलते हैं कि 200 रुपये निकाल कर।
सेकेंड हाफ में रखिए।
ठीक।
लेके आइए आप ऑर्डर। यहाँ खुल जाएगा ना ऑर्डर। केस का नंबर दे दीजिए। हाँ। केस का नंबर दे दीजिए।
ये प्रेयर में लिखा हुआ है एंड और हम दे दें कॉपी। और हमारे पास अभी कोर्ट नंबर 8 में ये सारा मैटर इसी के आधार पर सिंगल बेंच वाला लगा था। ये एलपीए के बाद में बहुत सारा रीड फाइल और सारा अलाउ हो रहा है इसी में, और वही ऑर्डर हम एक तो दिखा रहे। हमको लगा कि ये केस उस कोर्ट में लगता था, अभी कुछ बोलने की जरूरत नहीं पड़ता, इसीलिए हम तैयार हैं।
अभी डिवीजन बेंच पे 4 दिन पहले ही ऑर्डर किए और मेरा ही ऑथर किया हुआ ऑर्डर है, ठीक है ना? इसलिए ये मत बोलिए दैट वी आर नॉट अवेयर ऑफ व्हाट इज हैपनिंग इन केस ऑफ पैरा टीचर्स।
नहीं वो सब पता है, मुझे सब जान है।
Passport case item 36, WPS 5802 of 2023.
Yes, petitioner.
Petitioner I have asked to bring the NTA judgment, however, WPS judgment and these honorable appeals.
Is there any direction to pay interest?
No, there is not. But Milord, after the passing of this judgment, if they're further making further delays.
No, they are not making any delay. They have already paid you.
They have paid in 2024 minutes.
That's right.
And the judgment is of 2019 minutes.
Okay, when was
The
it passed
LP
that it will be an order in rem? You were not the petitioners there.
2019 minutes, in LPA number 560 of 2017.
We cannot, we will not pass any order on interest. Discretion, we will not exercise that discretion.
That is a statutory interest. That is
Go
the
to them
provision
only,
has
let
been-
them pass an order on your statutory interest. We do not. But 226, I am not inclined. I am not inclined to pass any order regarding pay because statutory interest under GPF is itself a contested issue. How much period? What is the date you apply? When till which period they can you can actually claim? There are so many nuances under that.
There are
Number of nuances under the act so far as the claim of interest also is concerned.
At least a representation may kindly be given direction upon me to make a representation with respect to the statutory
No, you
interest that
can
is-
withdraw your case to avail your remedies what may be available under law. I will not pass any order for, you can move the authorities under the Payment of Gratuity Act or whatever.
Yes, after
No,
passing
no,
of
no,
this
no, we
order,
cannot
because in
open a
LPA
Pandora box like that. You go before the authority, let them decide. You withdraw the writ petition and have your grievance redressed through appropriate. We can't do it like that. Because none of the petitioners have been granted the benefit of interest and we are not inclined to exercise power under 226.
even
Your rights are not going to be defeated. You can withdraw and pursue your remedies, whatever be the remedy.
because this LPA order came in 2019.
You can just persuade a court for exercising power.
Yes, yes,
You
definitely.
cannot
Definitely.
bind me to exercise my power under 226.
Only my prayer and my submissions may kindly be recorded, and that may be whatever calls from my.
Then I
authority
will say that I am not inclined to exercise power under 226.
Whatever calls from my.
You want a decision?
Yes. Definitely.
Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel submits that the petitioner had moved earlier before this court in WPS number 3520 of 2022. Where is the order? 3520 of 2022.
Well, it's LPS 560 of 17. That order is not with me. In this file, it is
No,
there.
you had moved in 3520, no?
Yes, yes.
Yes. I moved this court earlier in WPS number 3520 of 2022.
That was a different petitioner is different.
Two.
Similar from the same college.
No, this is what you have mentioned in your petition.
Actually, my lord, three petitioners, they preferred a single writ petition earlier.
You
that we withdrew for filing
No,
of.
para number 2.
Yes, yes, my lord.
Petitioners had earlier moved in WPS number. Is it incorrect?
In a separate writ petition, my lord, that's what I was explaining.
Petitioners?
There were three petitioners in one of the writ petitions, my lord, including this present petitioner and that
I
one.
want to know from you, madam, whether this writ petition WPS number 3520 of 22 was filed by you or not.
No. It
So
was
this
not
is an incorrect statement.
No, my lord, because a separate writ petition was filed.
When you say petitioners had moved, you have to say no, other persons have moved.
That's what, I withdrew that writ petition earlier.
Which was your writ petition? Which was your writ petition which you withdrew?
She was one of the co-petitioners in 3502 of
My lord,
of
I
22.
tender apologies, my lord. In 3520, three petitioners moved, two petitioners withdrew, and Ram Prasad pursued with this writ petition, my lord. And for then, thereafter, these two writ petitions were filed, serial 36 and 37.
Two petitioners withdrew.
Yes.
Where is your order of withdrawal? And what was the relief you sought for?
Same relief
We
was
do not know. Where is the order of withdrawal?
3520.
WPS number 5802 of 2023. Learned Counsel for the petitioner submits that the petitioner had moved earlier in WPS number 3520 of 2022. Post this case tomorrow along with the records. Under the same heading. हाँ उसके साथ that is disposed of. जो number बोले ना that is disposed of. There are two cases.
दो केस.
Both the petitioners had moved.
हाँ, both the petitions. Serial 36.
Both the cases.
Sorry for the inconvenience.
You should withdraw a case. You should put what is the relief prayed for. You do not. I don't know. The orders do not reflect that what is the relief you are praying for. That is why I always quote the prayer by even for an order of withdrawal.
Definitely. Latches on one. Henceforth, I leave it. Okay.
Item 44, WPS 5867 of 2023.
Yes, petitioner.
Earlier, the petitioner, along with others, had moved to this honorable court, my lord, and it was observed to file representation before the authority concerned.
Then?
And that has been decided, wherein it has been
Where is the decision?
It is annexed 7 page 36. Now they are saying that since the petitioner has retired from the post, now they are saying that it is the petitioner was not working against the vacant sanctioned post, so no benefit to be given to him. The state as well as the college university has to file counter.
Where is your appointment letter?
That letter is not actually with me, my lord, but it is not with me at present. But
That is the basic document.
so it is nowhere denied that I was not working with the respondents, under the respondents, and I have not superannuated therefrom. It is not denied.
You were getting salary,
Yes, I got salary.
but you were not working under against vacant sanction.
No, now
So
they are
therefore, is it a case of illegal appointment or it is a case of irregular appointment? How many years have you worked?
I have worked there, my lord, about 41 years. 41 years regularly.
Who released your salary?
It is being released by the on the payment by the state through university.
The state was releasing the salary?
Yeah.
University got
No, must be the grants must be given by you only. The state must have given the grant. You take work for 41 years and then you say that you will not get pension, and then you say that you have worked under against vacant. The post was not vacant and not sanctioned.
So far in this respect, we need some time to reply the query of the court orders. That has not come in the earlier repetition also. Reason order has been passed is annexed as annexure 7 page 36, and it has been clearly mentioned that the posts were not sanctioned.
If my lord will look, my lord, one page 28. It is a document of the college in serial number 11, my lord. Serial number 11, Q, Sri K N Singh, 1/11/1979, कर्मी स्वीकृत पद के विरुद्ध विधिवत रूप से नियुक्त एवं कार्यरत हैं।
There was a exercise of regularization also at one point of time. What have they mentioned in page number 38? In pursuance of orders of Honorable Supreme Court, in contempt, etc. The services of the petitioners were regularized with effect from 1/8/1993. What is it?
Yes. In pursuance to order of the Honorable Supreme Court of India dated 17/1/1994 in contempt petition number 280 and 404 of 1993, and also the order dated 25/9/1991.
What is it? What is this?
Passed in W petition C 409, the service of the petitioners were regularized with effect from 1/8/1993 or the date of joining, whichever is latter against the post sanctioned by the state government by letter number Etna by the Bhava University Hazaribagh by the number dated Etna. However, from the order of the Director Higher Education, it appears that the post on which the petitioners were working were never sanctioned by the Higher and Technical Education Department, Government of Jharkhand. Therefore, the recommendation of the four petitioners dated 13/3/2021 does not have any.
Kedarnath Singh. Where is your name? In any of the documents which you have annexed, where is your name? Kedarnath Singh, KN Singh. Where is that?
If my lord will look into page 28. Page 28, BSK College Method धनबाद पंचम एवं षष्ठम वेतन लंबित वेतन निर्धारण कार्यरत वर्ग 4 के कर्मियों का विवरण. In this letter, my lord, page serial number 11, क्रम संख्या 11. Serial 11, प्यून श्री KN सिंह. योगदान की तिथि 1/11/1979. कर्मी स्वीकृत पद के विरुद्ध विधिवत रूप से नियुक्त एवं कार्यरत हैं. सेवानिवृत्ति मृत्यु तिथि यदि कोई हो.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner has worked in the respondent college.
Yeah, BSK college, BSK college method, it is a respondent number.
Worked in in BSK college method, represented through respondent number 4 for more than 41 years. For more than 41 years, and he was also paid
for about 41 years.
For about 41 years, and he was also paid salary duly disbursed by the state government to the concerned university. But by virtue of the impugned order, the petitioner has been denied all the benefits by stating that the petitioner was not working against a vacant sanction post. The learned counsel has submitted that though no appointment letter has been brought on record by the petitioner, but the fact that petitioner had worked is not in dispute, even from the impugned order involved in the present case. The learned counsel appearing on behalf of the respondents are directed to seek instructions and file a counter affidavit in the present case to explain as to under what circumstances the salary etc. was released by the respondent state to the petitioner through university when they have passed an impugned order stating that the petitioner was not working against vacant sanction post. And they should also explain in the counter affidavit as to how the You are seeking retirement benefits.
Yes, my lord.
How the retirement benefits can be denied to the petitioner
And the benefit
after
of,
having taken work from him for long 41 years.
There is no prayer, Lord.
I am seeking, my lord, the benefit of fifth and sixth
Very,
pay
very.
revision.
Are you getting retirement? Retirement benefits you are getting? Pension you are getting?
Yes, yes. I am getting but less. But less, only 4,100 rupees.
Just a moment.
So I am
For the relief as prayed for in this writ petition, the counsel for the petitioner has submitted that the petitioner is already getting pension
but less.
from the state government, but the quantum of pension would change once the relief prayed for in this writ petition is granted to the petitioner. You file your congratulations. AG, वो भी है क्या? Accountant General is also there. Issue notice to respond number 4 for which requisites under ordinary process and speed post be filed by day after tomorrow. Office is directed to for speed post and ordinary process. Office is directed to track the speed post delivery and prepare office note regarding delivery of notice. Post this case on 12th of March 2023 under the heading for admission.
Okay.
आप एक डिविजन बेंच का जजमेंट है ऑनरेबल जस्टिस चंद्रशेखर wherein the pension was granted and the honorable division bench has held that once the pension has been granted they cannot say that you were not working under vacant sanction. That amounts to approval of service. It's a very short order. Recently relied also when I was in division. One order to that effect has been passed.
Item 45, WPS 5876 of 123.
Yes, petitioner. It's the same thing.
Yes, when the petitioner wants a shift from post of promotion of SC to.
Similar orders have been passed by this court, I suppose.
Well, the order which has been annexed pertains to the promotion matter which was pending before the learned coordinate bench, wherein the entire promotion avenues in the state of Jharkhand was kept at abeyance.
That's right.
That order has been put at.
That has been vacated,
Yes,
but
ma'am,
thereafter one order has been passed by Honorable Justice Rangan Mukhopadhyay. I think it has this matter. I am posting it tomorrow.
Well, in this case, the petitioner wants shift of superintending engineer, the date of shift of superintending engineer from 25/9/2018 to 31/2016. But the fact is that, that the petitioner was promoted to the post of executive engineer in the year 2014, and the petitioner himself has brought on record the Kalavdi which is required for promotion to the post of executive engineer to the post of superintending engineer. That is 10 years, and after calculating that also it comes 2019. Say suppose the petitioner was promoted to the post of executive engineer in the year 2014 and 10 years.
Petitioner is absent.
Yes,
Where is he?
petitioner is not present. A counter is required, in this case. Because it appears because we have received, earlier we had already received a statement of fact, but that was not appropriate. We have returned back. They are again making a fresh statement.
How much time will you need?
3 weeks maybe.
3 weeks. You have
Because
said
we are-
everything. You know what is it all about.
But they are making in the process of making that SOF again.
WPS number 5876 of 2023. Nobody appears on behalf of the petitioner. The learned counsel for the respondents has submitted that the claim of the petitioner is devoid of any merits. However, he submits that a short counter affidavit will be filed in the present case to explain the entire gamut of affairs. Pose this case on March 4th, 2023 under the heading for admission. The counter affidavit should be filed latest by 27th of February.
Item 46, total case 5991 of 2023.
Petition is challenging the annexure 4 wherein her prayer for compassionate appointment has been rejected by the respondent. This is the second round of litigation.
On what ground has it been rejected?
They said, brief, I am just stating certain facts, Your Lordship. In 2006, the petitioner's father died, 25th March 2006.
Just a moment. Yes.
And starting from April 2007 till December 2010, the petitioner's mother was provided monetary compensation by the BCCI. And in 2000, since she died in, petitioner's mother died in 11th of January 2011, post that monetary compensation was stopped. Now the ground for rejection is that since we have already paid monetary compensation to your mother in lieu of compassionate appointment, that's what they say, so we cannot provide you compassionate.
Did you apply for compassionate?
Yes, several times.
When did you apply?
I have starting from 2010, Your Lordship. I have been continuously.
No, they have their own time frame.
Your Lordship, I have brought it on record, Your Lordship.
No, but they have their own time frame. You have not applied it within time sheet.
I have annexure 1 may be kindly taken. I have, in 2010 only I have applied.
2010 is too late.
In 2000, yes.
Show me the provision under which you could have applied for compassionate appointment. What is your age?
Age currently 35.
Currently 35. What was your age in 2010?
23.
23. What was your age on the date of death?
Date of death 26, 19, around 19 years.
What is your date of birth?
Date of birth is, Your Lordship, 35 if 2023.
You don't have your date of birth.
Date of, Your Lordship, on 90, on the date of death of my, when the application was made in 2010, I was 23 years of age. 2006, my father died. At that point, I was 19, around 19.
But you never applied. You were eligible.
At that point of time, I didn't.
But you never applied.
No, I didn't apply at that time.
Then
I
you
applied.
can't apply later also.
The ground for, I'm only on one point.
No, you satisfy me as per their policy. We will not just restrict ourselves to the ground. You just tell us.
First, there is not disputed that the first time I applied was in 2010 only, and
That's the end of the
subsequently I have applied on afterwards, Your Lordship, because at that point of time, since I was 19 and 20
after 2010, when did you
Yes.
when did you file your writ petition? You filed your
2020.
2020.
Yes. Your Lordship, the 2020, the writ petition, the first para of the writ petition may be linked that I have applied for representations on 2011, 18, and 18. That is the first paragraph.
Very good.
Continue, but the ground for rejection is that we are not going to give you because you have already provided monetary compensation to the mother for a period of 3 years.
That's right.
That is the only ground, Your Lordship. And I am saying that you cannot debar me from the delay ground, Your Lordship. What you are suggesting, I am aware of that. The compassionate appointment is not a vested right. That is there.
It has to be as per the circular. What is the time frame?
Your Lordship, in state government it is 5 years, Your Lordship.
5
As per,
years.
under the state government.
State government.
This is state government?
No,
Your
BCCL.
Lord, this is BCCL.
We are not concerned
BCCL.
with state government. BCCL is
Period.
18 months. 18 months.
Yes, Your Lordship, as per NCWA.
NCWA, right?
Yes.
Explain.
Lordship, at that point of time, I had not. Our first application was made in 2010 only when she was 23 years old. Her
That was certainly beyond the prescribed period under NCWA, and in the meantime, your mother availed a monetary compensation.
for 3 years, from 2007 to 2010.
And he is reviving the stale claim by filing the representation. 2018 files. and
You don't
then
oppose.
2000.
You don't oppose.
Yes.
When the order of representation is being passed, you do not oppose.
Yes, that's it.
WPS number 5991 of 2023. this writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the father of the petitioner expired on 25/3/2006, and at that point of time, the petitioner was 19 years of age. However, on account of death of his father, monetary compensation was paid to his mother, said to be in lieu of compassionate appointment, and she availed of the same till the year till
Till her, till
11/1/2011,
yeah, till the death of her mother.
when she expired.
Mother died on 11th of January 2011, and from January 2011 that was stopped.
Right. The learned counsel submits that in the meantime, the petitioner applied for compassionate appointment in the year 2010, and when the same was not being considered in spite of repeated representations, he filed a writ petition on being in the year 2020, being WPS number 228 of 2020, wherein the respondents were directed to consider the representation of the petition, consider the pending representation of the petitioner and pass a reasoned order within stipulated time frame. The learned counsel submits that as per the reasoned order, the petitioner has been held to be not entitled for compassionate appointment on the ground that the mother of the petitioner had availed the monetary compensation in lieu of compassionate appointment. The learned counsel submits that the claim of compassionate appointment could not have been denied on such a ground. The learned counsel, appearing on behalf of the respondents, on the other hand, while opposing the prayer, has submitted that as per NCWA, the period prescribed for applying for compassionate appointment is 18 months.
Yes, that I'll give you.
Please give a copy.
Yes, that
Is
I'll
18 months, and admittedly the petitioner did not apply for compassionate appointment within the stipulated time frame. Although on the date of death, the petitioner claims to be 19 years of age. The learned counsel has also submitted that the petitioner did not, the learned counsel also submits that the petitioner did not avail the legal remedies for 10 long years, although he is said to have filed the application for compassionate appointment in the year 2010, and the legal remedy was availed only in the year 2020. The learned counsel submits that merely because there was a direction to consider the representation, the same cannot wipe out the fact that the petitioner, having filed the representation as back as on, having filed the application for compassionate appointment as back as on in the year 2010, did not take any recourse to law. He has also submitted that much time has elapsed and therefore the petitioner is not entitled for any relief. He has also submitted that so far as monetary compensation is concerned, the same is paid in lieu of compassionate appointment, and in lieu of compassionate appointment. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the father of the petitioner expired on 25/3/2006, and the mother of the petitioner availed the monetary compensation in lieu of compassionate appointment till her death on 11/1/2011. The petitioner claims to be 19 years of age on the date of death of his father, but he did not apply for compassionate appointment within the stipulated time frame, and applied only in the year 2010. the petitioner did not avail any legal remedy till 2020. And in WPS number 228 of 2020, an order for consideration of the representation was passed by this court on the basis of submission made by the counsel for the petitioner that it would be suffice if direction is given to the respondents to take a decision on the representation of the petitioner and passports. Thus, while considering the writ petition being WPS number 228 of 2020, this court has not adjudicated upon the merit of the case of the petitioner and his entitlement. This court is of the view that the mother of the petitioner, having availed the monetary compensation in lieu of compassionate appointment, and further, the petitioner did not apply for compassionate appointment within the time frame, and also the fact that much time has elapsed from the date of death of the father of the petitioner way back in the which happened way back in the year 2006. This court is not the impute order does not call for any interference according to this petition is hereby dismissed.
It is 1 year, Your Lordship, as per the standard.
You give me that.
Yes, Your
You
Lordship.
get a print.
Yes, Your Lordship, I'll give the print.
Yeah, you give it. It is 1 year.
Yes, as per the standard operating procedure.
We do
It
not.
has been made effective from 1/6/2020.
No. We are not concerned. There is a provision.
NCWA, there is.
18 months.
18.
Please help him. He doesn't know anything. He's appearing for BCCL. You don't know these basic things.
18 months.
One case in 20 cases is a case of compassionate appointment against BCCL. You are not aware about the provision. Give me that provision, please.
Yes.
Ask him, he will do it.
Yes.
Yes. बाकी सब ये खत्म हो गया कितना बाकी है कहाँ तक Okay, let us see. Defective cases the pages of
False with defect item 1, WPS 1146 of 2023.
Yes, petitioner.
Notice the defect is for filing of fresh copy of page number 42, which is the part of the order passed by the department. The fresh copy has been filed, but the same is not legible. The defect may kindly be ignored, as in the fresh copy also it is not legible.
This is the only defect.
Yes.
Learned counsel for the parties are present. The learned counsel for the petitioner submits that the only surviving defect is in connection with page number 42. He submits that page number 42 is a document of the respondents and the photocopy which has been filed is not legible. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. And also,
Counter has been filed on behalf of respondent.
You have annexed it?
And for the state.
You have annexed it?
No.
Counter has been filed by whom?
Respondent state, higher technical education.
Whose document is this?
It appears to be document of higher technical education.
The learned counsel for this counter affidavit is not on record.
Not on record.
Not filed. Check kariye. Counsel for the respondents. You don't check it. Is it not available? It may be there in your record. Who is concerned about that? File हुआ? Not filed. The learned counsel for the state is directed to seek instructions and file a counter affidavit in the present case and also furnish legible copy of the impugned order This is a part of impugned
Letter,
order.
Letter dated 8/11/2019, which
Legible
by which
copy
the
of
pay scale of 6
the-
pay was.
This is the impugned order.
No letter.
Legible copy of annexes, page number 41 and 42 of the writ petition. University is also party. You are for the university. Learned counsel for the respondent university is also directed to seek instructions and file a counter affidavit. The counter affidavits of the respondents should be filed by 19 February. Post this case on 21st February. Under appropriate, the surviving defects is ignored.
Item 2, WPS 1183 of 2023.
Yes, petitioner.
Two pages of the same annexure has been filed. We may be permitted to delete one of the pages. That's the only annexure 2.
1 to 4, there are so many defects. Which page do you don't want to rely upon?
Page 27.
Page 27.
'26 and 27 are the same pages. One of the pages will be 27.
Oh. Okay, the learned counsel for the petitioner submits that he would not rely upon page number 27 of the petition, which is repetition of page number 26. You have filed. Accordingly, the defect number 3 be ignored. Consequently, the defect number 3 is hereby ignored. So far as other defects are concerned, the timetable 29th February is granted to the, not 29, time till 19th February or time till 22nd February is granted to the petitioner to remove the remaining defects. Preemptory, if the defects are removed within time, post this case on the 28th of February.
Item 3, WPS 1184 of 2023.
Yes, petitioner. Same order.
Item-
Under appropriate heading condition.
Item 4, WPS 2301 of 2023.
Yes.
1 week time. Remove that.
Same order.
Item 5, WPS 2302 of 2023.
Same order.
Page number 30 is the deleted permission delete. Not eligible. Page 30.
What is page 30?
30.
You don't want to rely upon? The learned counsel for the petitioner submits that he shall not rely upon page number 30 of the writ petition. Considering the submissions, the defect number 2 is ignored. The counsel for the petitioner is directed to delete page number 30 of the writ petition in red ink during the course of the day. Strike off कर दीजिए उसको. Strike off.
उसको भी दिया जाए कल हमने लाया काउंटर पर रिजल्ट
Counter has been filed. Rest of the defects have been removed.
साइड को भेजना ऑलरेडी
defect number, the defect regarding page number 19 having been filed twice is also ignored. The remaining defects we removed within both the time then time frame से frame order है बाकी defect remove कर दो.
2 week.
I do.
Item 6, WPS 2305 of 2023.
What is the date you tell him? What is the date? बताइए उनको date बताइए कि कब तक remove करना है.
22.
Best. No.
Next. Who is for the petitioner?
ड्यूरिंग द कोर्स चेक कर लीजिएगा.
हम कर लेते
Same order. Are you there?
Type copy.
You have to file court fees also.
Court fees is paid.
We do not know. You remove the defect. It's a painful time. You see the file, madam. Your case will be dismissed for default if you don't see the file properly. Right? You are there, madam. You are there. Sir? Help her, please. She might not know. File दीजिए उनको. Tell her, right?
Item 7, WPS 2308 of 2023.
Your ladyship, the defects which are still remaining is type copy of page number 36, 62 and 63. Your ladyship, I am saying that this may be ignored, your ladyship.
36,
as I'm
62
not
and
relying
63.
upon these pages.
How you can't, you see, you cannot say that you will not rely upon one page of a document. Either you rely on the entire document or you don't rely on the entire document. You cannot say that one page of a particular document you will not rely on. Not possible.
Your ladyship, the type copy is also very difficult to get it. Moreover, your ladyship, the matter was taken up on 6/9/2023, your ladyship, wherein.
Why is it difficult to get a typed copy of this?
Your ladyship, I have filed the type copy.
This document is with you?
Yes, your ladyship.
Your service book is with you?
Yes, your ladyship.
So why can't you get it typed?
I have done it, your ladyship, but it is still saying that it is ineligible. Page number 36, your ladyship, but page number 62 and 63 may be ignored, your ladyship. Your ladyship, this matter was taken up wherein the bench had ignored it by orally, your ladyship, and has directed to file counter affidavit.
These documents have already been ignored?
Yes, your
This
ladyship.
defect has been ignored?
Yes, your ladyship.
Where is that?
It
Where
was
is that
done
order?
Orally, your ladyship. And
Orally, no oral orders have. We cannot do anything.
There was a direction to file counter affidavit.
These are not the documents. Are these the documents of the respondents?
No, Your Worship, these are the documents.
These are
of
your
the
documents.
Yes, your ladyship, but I'm not relying on these.
Okay, then you strike it off.
I'll strike it off.
You and then you strike off your service book also entirely. I will not permit you to strike off one page of a document. Right? The learned counsel for the petitioner has submitted that she will not rely upon the service book including page 36 and also page number 62 and 63 of the writ petition. And therefore the defects with regard to page number 36, 62 and 63 be ignored. The learned counsel for the respondents has no serious objection to the prayer admitted. Accordingly, the petitioner is directed to strike off in red ink the pages of service book commencing from page number 54. 54 is also a part of service book.
Yes, your ladyship.
You have
From
just
54. From 54, your ladyship.
when page number 36 is also a part of service book.
Yes, your ladyship, that starts from page number 34.
So you will not rely upon page number 34 too?
34 to page number 48. 48.
54 is also a part of service book.
Yes, Your Worship, I'm not relying upon that.
So that is a different document. Page 49 is
That is
Prapatraka.
different, actually.
Prapatraka, and it is a different document. It is the part of the order, page 51.
Strike off page number, tell us, page number?
34 to 48.
34 to 48.
Yes, and thereafter
And page number 62 to 63.
54.
62 to
62 and 63.
62 and 63. 54 is not a part of service book.
It is a part of the service book. From 54 to 63. 54 to 63.
So you will be striking off page number
34 to 48.
34 to 48.
Thereafter 54 to 63.
63. The learned counsel submits that she would strike off the pages from page number 34 to 48 and page number 54 to 63. She is permitted to do so in writing during the course of the day. Post this case, accordingly, the surviving defects in connection with page number 36, 62 and 63 is ignored. Post this case under the appropriate heading on Monday.
करेक्शन कर लीजिए.
Item 8, WPS 2309 of 2023.
सेम ऑर्डर करना. वो वाला ऑर्डर किया था ना?
Item 9, WPS 2311 of 2023.
For 1 week time.
Same order.
Item 10, WPS 2321 of 2023.
Same order.
Item 11, WPS 2344 of 2023.
Same.
Item 12, WPS 2345 of 2023.
Same order.
Item 13, WPS 2357 of 2023.
Same order.
Item
All
4,
these orders are preemptory orders, and the cases will come upon, if you remove the defects, it will come up on 28th of February.
Item 14, WPS 2380 of 2023.
Same order.
Item 15, WPS 2385 of 2023.
Lord, only one page, if my Lord may be kindly please to ignore the same. Page 77 remains.
Page 77 is to be ignored.
My Lord, that is the defect indicated. My Lord, I had gone through the office notes.
Is it a part of the document? If it
Yes.
is a part of the document, we
Yes.
will not ignore it.
It is part of
Then you have to remove the entire document.
Annexus 69.
We cannot ignore the defect in connection with one page of the document. If the document has to be relied, it has to be relied in toto or not relied in toto.
No, my Lord, I was saying that it is fairly legible if it, my Lord may kindly
Only
consider.
ignoring. Page number 77. No, you have to file it. It's not legible. In my copy, it is not legible. Same order.
Item 16, WPS 2806 of 2023.
Same order.
Item 17, WPS 2840 of 2023.
Same order.
Item 18, WPS 2884 of 2023.
Same order.
Item 19, WPS 3008 of 2023.
Same order.
Item 20, WPS 3062 of 2023. Item 21, WPS 3070 of 2023.
Same order.
Item 22, WPS 3100 of 2023.
Number 1 and 6 has been filed in this year, and defect number 2 is only surviving. Only 2 weeks.
Same order.
Item 23, WPS 3251 of 2023.
In this case, the defect pointed over the staff reporter regarding the court fees concerns me. The simple judgment passed by this honorable courts, the several civil petitioner is there, but we have filed the one court.
They are claiming the same relief.
Claiming
What
the
is the
same.
relief they are claiming?
Claiming the same relief.
No, what is the relief? They are agreed by one order, or they are claiming regularization. What is it they are claiming?
Claiming the promotions.
Each have a separate cause of action. Promotion of each person is a distinct cause of action. I will not pass that on. You satisfied?
Claiming the promotion.
WPS number 3251 of 2023. The Learned Counsel for the petitioner submits that the petitioners are claiming promotion and he submits that he has filed one set of court fees. That should be sufficient. Considering the nature of relief prayed for, this court is of the view that each petitioner has a distinct cause of action and therefore one set of court fees is not sufficient. The petitioner is directed to file the remaining court fees within stipulated time of condition. The remaining defects, if any, we also remove. Okay.
हाँ सर सर मात्र एक कोर्ट फी का है
आप फाइल कर
I
दीजिए.
will file not I will file by tomorrow. When the date we fix now.
You want to file it by tomorrow?
Yes, yes. I will file.
The council, at this council submits that he would file the remaining court fees by tomorrow. Let it be, let the court fees be filed by tomorrow. Post this case under appropriate heading on Monday.
Item 24, WPS 3609 of 2023.
It's Supreme for 2 weeks time.
Same order.
Item 25, WPS 3610 of 2023.
Same order.
Item 26, WPS 3620 of 2023.
Same order.
Item 27.
There were two defects, my lord. With respect to defect number 1, my lord, the enclosure of caste certificate is not there, my lord. I may be permitted to strike off the portion of caste certificate as indicated at page 18, my lord. And except 4 series, my lord, it was indicated that caste certificate is also enclosed, but it is not enclosed. I may be permitted to delete the enclosure of caste certificate.
Page 18.
Yes, my lord. Page 18 in the indented paragraph, third line from the fourth line from the bottom.
All right. What else?
My lord, the other defect is defect number 2 of synopsis that I will find it in a week.
The Learned Counsel for the petitioner submits that with regard to defect number 4, office has pointed out regarding that the caste certificate has not been filed. He submits that caste certificate may not be required and therefore the defect be ignored. Counsel for the petitioner further submits that the remaining defect will be removed as by 22nd. Counsel for the petitioner, the defect with regard to filing of caste certificate is hereby ignored. Counsel for the petitioner is permitted to carry out necessary correction in page number 18 of the writ petition and at other places.
index and synopsis.
in the index and synopsis. In the index, the remaining defect we remove by 22nd preemptive. If the defects are removed, post on 28th.
Item 28, WPS 3666 of 2023.
3 weeks time.
Same. Time till 22nd is there.
Item 29, WPS 3675 of 2023.
But if there are 3 defects still remain, out of 2, defect number 5 and 6 I will remove during 2 weeks, within 2 weeks. For defect number 1, that is a defect, it is advertisement, annex 1 is advertisement and it is paper cutting not. Date is not mentioned in that annexure also, so that may kindly be ignored now. I have tried from several sources, but I am not getting the date. But it is the main advertisement which
You have mentioned your
paragraph 6 was annex 1. 2 defects I will remove.
You have mentioned the date of that.
Page 9, paragraph 6. Defect has been pointed that advertisement dated mentioned in paragraph 6 does not appear in the annexure. It may be
The learned counsel for the petitioner submits that the defect regarding date of advertisement having not been mentioned in annexure 1, which is a paper cutting, be ignored, as he is not able to get the newspaper of Dainik Jagran dated 9/7/2009 to substantiate his statement made in para 6 of the writ petition. The aforesaid defect is ignored for the present, subject to any objection which may be raised by the respondents while filing their counter-affidavit. Subject to any objection that may be raised by the respondents, the respondents are free to file their supplementary counter-affidavit.
And 5 and 6 I will remove
Within a
within
period of 15 days from today. Let the matter be posted under appropriate heading on 28th of February.
Item 30.
The remaining defects be removed by 22nd February.
Item 30, WPS 3697 of 2023.
Yes, petitioner.
2 weeks time.
Same order.
Item 31, WPS 6083 of 2023.
File an IA for ignoring the defects of our court fees, since common cause of action is involved in this writ application.
The matter relates to
Quashing of the order passed by DSC, by which 512 para teachers have been stopped from working.
where is it?
Page 72.
Lordship, may I just inform you, Lordship, about 18 matters was listed before another court date by us. It is coming on 20th it has been fixed with us.
You have the cases, number of cases?
Case number.
Case numbers.
Of the supplied minutes.
Is it up to 2023 or
2023 minutes.
So it will come before
Same
this-
matter, same order,
before
same
this,
form.
before this court only it will come then.
Almost,
If it is
this-
WPS 2023, then it will come before this court only.
Well, that's what I beg to humbly submit to Lordship, that since this arising out of the common impugn order, I would request to Lordship to list it thereafter or along with that minutes only I
It
can
will
make
come
it
along with
notes.
that. When is it coming? Give me the
20th
list of
20th
cases.
February. I'll just supply notes.
And what about the court fees?
कोर्ट फीस तो इनको देना चाहिए वो जो
Common
इंडिविजुअल
cause of
रिलीफ है
action.
उस पर हम ऑब्जेक्शन करेंगे वो जो इनका
करिए. You are aware of the judgments. It can be
It's
decided by
individual
one
relief
stroke.
bills.
It can be decided by one stroke of pen. That is the test.
Yes, but
All the para teachers have been directed to discontinue by impugned order as contained in Annexure 3, which can be decided by one stroke of pen. Which can be set aside by one stroke of pen.
Yes, I humbly beg to submit to Lordship that it is a matter of two blocks and there are certain differences. Somewhere there is not qualified, somewhere there is advertisement was
So
defective.
everybody has their separate cause of action.
There is a Millards, they have filed it in a club in their own convenience, but everybody have a different fact.
You
And
file your objection to the IL.
I will do this. I will not say give him this for this.
WPS numbers 4 weeks.
2 weeks not.
You don't need to actually seek instructions for this. This is a legal issue. You do it 2 weeks, right?
Yes, I am.
WPS number 6083 of 2023. The counsel for the petitioner has submitted that one interlocutory application has been filed to pass appropriate order in as much as the remaining the other set of court fees need not be filed in the present case. Counsel for the respondents, JEPC.
JBC in a state also means
JSP and state are directed to seek instructions and file a counter affidavit to the interlocutory application. The counter affidavit should be filed by 22nd of February 23. Close this case on 28th of February. By rest of the defects have been
Yes, I have removed.
all right. Check. You get hold of all the orders. There are numerous orders. The first one being by Honorable Justice B.M. Lal.
I think that is the question still was popping up.
No, we'll decide it. Don't worry about it. You just assist. We will decide.
Lots. Developments.
Regular first case.
Item 47, WPS 6004 of 2023.
What is it?
This is the second round of litigation, Lord. Annexure 6, page 50.
WPS number 6004 of 23. Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in this case by 22nd of February. Post this case on 27th February under the heading for admission. Next.
Item 48, WPS 6028 of 2023.
Lord, this is a compassionate appointment matter.
Okay.
And my lord, the father of the petitioner, my lord, died on 11/2/2010. But it is only after the death of the father of the petitioners, my lord, that the state government, my lord, came out with a resolution dated 12/5/2023 and Annexure 6. Lord, that my father has been regularized and other similarly situated employees of BSRTC has been regularized. So, not for the first time after regularization, my lord, I seek, my lord, compassionate appointment.
No, not the first.
It is for the first time, my lord.
Maybe it is not your, right which accrues after his regularization.
Lord, death or retirement, my lord, is never an obstacle for the state to consider.
Compassionate appointment is not your right. It is something which has to come to you as a rescue to tide up with your immediate affairs.
Lord,
What was your age in 2010?
Lord, it was 17, my lord, my date of birth was 16.
Your age was 17 years?
16,
You were not
11.
entitled. On the date of death, otherwise also you were not entitled.
Lord, I have not, my lord, filed any representation before
Need
the
not.
authorities.
We will not.
Lord, if your lordships, my lord,
Order of representation will be not mechanically passed against you. I am very, very firm on this. You have to prima facie satisfy this code, then only there will be an order of representation.
Lord, my case is that it,
WP S number 6028 of 2023. The learned counsel for the petitioner has submitted that the father of the petitioner had expired as back as on 11/2/2010, but order regularizing his services pursuant to various orders passed by this court and Honorable Supreme Court has been passed by virtue of notification dated 12th of August 2023. And therefore, he has a right to seek compassionate appointment. The learned counsel, upon the query of this court, has submitted that on the date of death, the petitioner was only 17 years of age.
being his date of birth at 16/11/1993. 16/11.
As his date of birth was 16/11/1993. Correct?
My lord.
Learned counsel for the respondents has opposed the prayer after hearing the counsel for the parties and considering the facts and circumstances of this case. This court is of the considered view that the services of the father of the petitioner having been regularized in the year 2023, though he had expired as back as on 11/2/2010, does not give rise to a cause of action to the petitioner to seek compassionate appointment. Otherwise also the petitioner was minor on the date of death of his father. And this court also finds that much time has elapsed from the date of death of his father, way back in the year 2010. Seeking compassionate appointment is not a matter of right. Compassionate appointment is given to the dependents of deceased employee to tide over the immediate crisis in the family. In view of the aforesaid circumstances, this court is not inclined to grant the relief as paid for by the petitioner, which is accordingly dismissed. Prayer court concluded. Next. Call continue.
Item 49, WPS 6030 of 2023.
Petitioner.
This case is related for the setting aside order hearing. The annexure 6 departmental proceedings have been initiated against me.
You have been dismissed.
No. Promotion, प्रोन्नति पर रोक और संचात्मक प्रभाव से 2 वेतन वृद्धि पर 2 increment was stopped and the promotion was stopped.
Counsel for the petitioner is present. The matter arises out of departmental proceeding. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 22nd of February 23. The rejoinder, if any, by 29, goes this case on 5th of March under the legal for admission. Other side को बता देंगे please. Call continue.
Item 50, WPS 6102 of 2023.
Yes, petitioner. Sorry? After lunch. We don't have that bench. You can do it.
I was waiting for time to seek instruction.
What is the matter about?
It is regarding compassionate appointment.
Who is she? What is the date of death?
It's the year 2020.
Why have you denied? Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 22nd of February. उसके ऊपर लिखेगा the matter relates to claim of compassionate appointment. Pose this case on 28th under the heading for admission.
Item 51. Item 51, WPS 6109 of 2023.
हम लोग का कल का कितना केसेस है हम लोग के पास? Pose this case tomorrow. संजीत जी देख के बताइए कल का फ्रेश फाइलिंग कितना है हमारे पास? चलिए कॉल करिए.
Item 52, WPS 6114 of 2023.
Yes, petitioner.
Wait, please. Lord, by annexure 5, Lord, at page 15, 25, the petitioner, Lord, who was selected provisionally as
Counter by
Anand
22nd. File your counter by 22nd. Post on 28th.
Lord, in the meantime, they नहीं वो वहाँ आम सभा करके
We do not know.
दूसरे को अपॉइंट
There is no separate interlocutory application filed. File your counter affidavit by 22nd. We are posting it on 28th. Positively do it. चलिए.
Item 53, WPS 6132 of 2023.
Counter affidavit by 22nd.
Later reads to compassionate appointment. The petitioner died on
Date of death?
2017.
11 to 2017.
What is the reason for denial?
Nothing denied, but he has applied.
When
but
did he
they
apply?
have not passed. He applied in the year 2020.
What is his age? What is his age?
23 years.
What was his age and on the date of death of his father?
23 years at the time of death.
You are already working. You are
No.
not unemployed.
No, I am not working. The mother of the petitioner applied for a death cum retirement benefit along with the compensatory appointment.
Where is your representation?
I have filed all annexer.
Where is your representation?
Yes, Lord. Annexer 2, Lord.
They have not taken any decision on that?
Not taken any decision.
Your Ladyship, in this matter, it would be relevant to go to page number 49. 49 is the recommendation. The bottom portion reads that it is thereby recommended for consideration of appointment on compassionate grounds with respect to so and so for relief of the deceased family.
Why don't you take a final decision?
Yes, we will take it.
The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that the father of the petitioner expired on 11/2/2017. Thereafter, the petitioner applied for compassionate appointment and appropriate recommendation has already been made by the Annexure 6 dated 12/13 or 13th of September 2022. But no decision has been communicated to the petitioner so far. And therefore, the present writ petition has been filed. The learned counsel for the respondents has submitted that appropriate order may be passed appropriate order may be passed so that the decision, so that the claim of the petitioner is taken to a logical end. That's it.
That's
After hearing the counsel for the parties and going through the through Annexure 6, which is dated 12th of September 2022, issued by the Assistant General Manager Personals of Food Corporation of India, this court finds that a recommendation for consideration of appointment on compassionate ground of the petitioner has already been made, but it appears that no final decision has been communicated to the petitioner. Accordingly, the this petition is disposed of, enabling the petitioner to approach the respondent number.
Your Lordship, that would be respondent number 2, General Manager FCI.
Respondent number 2, within a period of 15 days from today, by filing a representation along with a copy of the records. Upon filing of the representation, the respondent number
all supporting documents will require there should be no objection भी इनको देना पड़ेगा वो सबसे लगेगा.
with all supporting documents, as may be directed to be furnished by respondent number 2. Upon filing of such representation and furnishing of supporting documents as may be directed by respondent number 2, the respondent number 2 shall take an appropriate decision within a period of 1 month.
6 weeks कर लिया जाए, 6 weeks.
Within a period of 6 weeks from the date of furnishing the required documents, and pass appropriate reasoned order in accordance with law. The reasoned order be communicated to the petitioner and to the petitioner through speed post. This court has not gone into the merits of the claim of the petitioner. No counter affidavit has been filed in the present case. Next.
Item 54, WPS 6133 of 2023.
May I please, Your Lordship?
Yes.
Your Lordship, this is a matter of promotion from sub-inspector to inspector, Your Lordship. The respondent number 3 has to, if Your Lordship may direct to file the counter affidavit. However, a counter affidavit has already been filed by respondent number 5, wherein they have specifically stated that they have complied all the formalities from their end. It is the respondent number 2 who had to perform their duties.
I'll post it tomorrow. I'll pass the order tomorrow.
Yes, please.
Counsel for the parties are present. Post this question. Next question.
Item 55, WPS 6146 of 2023.
Yes.
pay of the petitioner has been reduced unilaterally without even hearing the petitioner.
Counsel for the parties are present. Counter affidavit by 22nd, post on 28th. Next.
Recovery, I was told that recovery is.
आने दीजिए लेकिन.
Item 26, WPS 6150 of 2023.
This is for payment of retirement and death benefits. Petitioner is the wife, husband was working as EP fitter on Purandi project. Died in harness on 21/4/17.
Your representation?
Yes, Annex 3.
15/9/23 is your representation.
Earlier there was one representation that has not been brought on record. That is of the year 22. There is some delay.
Who's for the respondents? You take a decision, right? You are seeking post-retirement benefits or
Yes.
also
Provident
compassionate
fund.
appointment?
Compassionate appointment, I have just been informed that has been granted to one son.
Okay.
That has not been able to, we have not pleaded specifically, that was left out.
All right. WPS number 6150 of 2023. The learned counsel for the parties are present. The petitioner, being a widow of ex-employee of the respondents, who is said to have expired on 21/4/2017, is seeking post-death benefits.
And provident fund.
Post-death benefits will include provident fund, etc. Right? Post-death benefit, the learned counsel submits that repeated representations have been filed by the petitioner, the lastly being on 15/9/2023, but no decision has been taken. The learned counsel for the respondents has submitted that the representation of the petitioner will be taken care of, the writ petition be disposed of. Who is the authority? By the respondent number? The accounts manager will not decide it. By the respondent number 2?
3.
Or 1? Or 3?
2.
Tell us.
Competent authority.
No, by the respondent number 3. Right? The learned counsel, this writ petition, considering the nature of relief sought for in the present writ petition, the writ petition is disposed of, enabling the petitioner to file a fresh representation before the respondent number 3, along with a copy of the writ records and a copy of this order within a period of 15 days from today. Upon filing of such representation, the respondent number 3 shall look into the grievance of the petitioner, or refer the matter to appropriate authority who is competent to look into her grievance. The concerned authority or the respondent number 3, as the case may be, are directed to pass appropriate reasoned order within a period of 4 weeks from the date of filing of such representation. This writ petition is accordingly disposed of.
Only one short prayer, to make that representation 3 weeks may be given because she is old age, she might not be able
2 की जगह 3 हफ्ता कर दीजिए भाई उनको.
थोड़ा दिक्कत है.
टाइम फ्रेम चेंज कर. चलो.
Item 27, WPS 6156 of 2023.
Yes, petitioner.
In this case, there are both pair, 5 pairs. First pair to shift the date of promotion as per the 1993 promotion rule from 2017 to 2003. As per the rule, Rule 5 speaks about the promotion is to be granted after the 8 years of the service. First from litigation, the one order is passed by the Honorable Court in case of Arun Sinha, and in compliance of that, the resolution has been taken by the estate that the grade 1 and seniority shall be granted from the
Seniority list has been prepared.
Seniority
list has been prepared. Have you prepared a seniority list?
But 8 years not granted.
WPS number 6156 of 2023. Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. By 4th of March, the learned counsel for the respondents shall ensure that the seniority list prepared by the respondents be also placed on record, and also indicate the vacancy position which may be required for the purposes of grant of promotion to the petitioners. The post this case on 6th of March under the heading for admission. Next.
Item 58, LPS 6157 of 2023.
I'm paying from not today. The counsel of this is out of restriction.
When do you want? At the request of the counsel for the petitioner, first on next Tuesday. Next.
Item 59, WPS 6206 of 2023.
Yes, petitioner.
Absolutely already been filed.
Counter has been filed. What is the matter about?
The petitioner prayed for dynamic asset career progression.
Okay. What is your counter? He is entitled, not entitled?
Not entitled.
Any order has been passed regarding his entitlement?
No, Lord. In para 8 is the specific, the relevant logic. I may be permitted to place it. It is stated that as per the amendment dated itna ACP scheme was introduced by finance.
All right. A counter affidavit has been filed in the present case. The rejoinder, if any, be filed by (19th of February). Post this case on 21st under the heading for admission. Next.
Item 60, WPS 6272 of 2023.
The petitioner is a lady in the year 2014, while initially she has been appointed as a teacher by the school management committee.
Which school?
RC Primary School.
Private school?
No, primary school. This is not government, government aided school.
Government aided school. You have a remedy under the education tribunal?
But since,
Figure it out.
Since 2014, madam, she is working not a single penny.
That's right. So you have a remedy under the education tribunal, isn't it? Do you have or you don't?
I have to check.
You check
Maybe
it.
posted tomorrow. I will.
WPS number 6272 of 23. Counsel for the petitioner prays that the matter be posted tomorrow so that he can find out if the petitioner has a remedy before the Jharkhand education tribunal. Post tomorrow.
Item 61, WPS 6305 of 2023.
Petitioner. What is the matter about?
The petitioner are claiming promotion to the post of university professor from the post of reader.
Counsel for the respondents is directed to seek instruction and file counter affidavit. Both university and state both. Counter affidavit be filed by 22nd. No, counter affidavit be filed by 29th February. Rejoinder if any by 11th of March. Post this case on 13th of March under the heading for admission. Next.
Item 62, WPS 6311 of 2023.
Yes, Madam.
Your Leadership, matter relates to pensionary benefit, counting past services of the petitioner. The identical matter is pending, Your Lordship. Readings are complete.
Which case number?
Case number 3882 2020.
2020.
2020.
It is pending.
Yes, Your Leadership. Readings are complete.
Status देखिए 3882 of 2020. इसका रिकॉर्ड मंगा लीजिए जरा. We'll post it tomorrow.
Out of this pending additional.
It may be posted.
It will be posted tomorrow. We'll see if it is same. We'll refer to the Honorable Chief Justice. He will constitute a bench who would hear these two matters together, right?
Alright.
With the request
It may be posted day after.
You are not there tomorrow.
Your Leadership, I have been directed not to post it tomorrow because we have various cases.
WPS number 6311 of 2023. at the counsel for the petitioner submits that similar matter being WPS number 3872 of 2020. 3882 of 2020 is pending before this court, in which is pending before this court. Pose this case on day after tomorrow. Day after tomorrow तो नहीं होगा ना, Thursday. Pose this case on next Tuesday. Office is directed to place the records of 388 WPS number 3882 of 2020 for perusal. Till the next, under the same heading.
Item 63, WPS 6340 of 2023.
Petitioner placed for direction upon the respondent to consider the candidature of the petitioner for the post of graduate trained teacher, math and physics, and thereafter may not issue a
This is advertisement of 2016.
2021, madam.
2016.
Advertisement, Jharkhand staff, but my lord, the 2016 Jharkhand staff selection issued advertisement on 21/2016, my lord. Appointment of graduate petitioner has already passed of the examination. He has issued admit card. He is also he has declared pass, my lord. And thereafter on verification, my lord, it is said that the petitioner kindly see annexure 6 on verification. Petitioner given the
You file your counter. Yes, what do you say? Stay case.
BC2 का
2016 advertisement your ladyship.
He was declared successful.
My lord, all process has complete.
File
For
a
state and therefore Jesus.
File a counter. Counsel for the parties are present. Counsel for the petitioner submits that although he was declared successful, but no appointment letter has been issued to the petitioner, and the reasons are unknown to him.
ना रीजन में BC2 का सर्टिफिकेट था वाला है वो BC2 का सर्टिफिकेट दिया था, लेकिन ये BC1 का सर्टिफिकेट बोलते हैं कि आप दिए इसीलिए आपका नहीं होगा, जबकि ऑलरेडी BC2 है हुजूर, और BC2 का सर्टिफिकेट भी दिए हुए हैं, BC2 का दिए हुए हैं, 2 सर्टिफिकेट इशू हुआ था, BC ग्वाला जाति के हैं और वो BC2 एनेक्सर BC2 है।
ऐसा नहीं होता ना,
मतलब I have annex में ना, kindly see annexure 6 में ना।
Anyways, counsel for the parties are present. The counsel for the petitioner submits that the candidature of the petitioner has been rejected only on account of filing of caste certificate under BC1 category or BC2 category, although he belongs to BC1 category.
ना BC2 belongs कर रहे हैं हुजूर, अब BC1 का बोलते हैं कि दिए थे, बाद में BC2 का भी दिए हैं वेरिफिकेशन, ना BC2 है, BC2 category.
The counsel for the petitioner submits that the petitioner was declared successful, but the candidature of the petitioner has been ultimately turned down on account of certain error in submitting caste certificate. But at the time of counselling, he had submitted the correct caste certificate. यही है कहानी. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 28th of February. The rejoinder, if any, by 11th March, post on 13th of March under appropriate. हो गया? खत्म?
Just filing complete.
Admission,
Second.